We continue with the debate on P30. The principles have been adopted. How do you move the matter in second reading?
En bloc, please, sir.
Is the matter seconded for second reading?
Yes, sir.
Does any member wish to speak in second reading? If no one wishes to speak in second reading, Deputy Catherine Curtis.
Thank you, sir. So I welcome the amendments to the regulations. I'm sure it will be a great help for people in very difficult circumstances. What I'd like to ask the Minister is how well will this change be publicised? So will it be made easy for people to apply? Because when a family member is caring for someone in these circumstances, they may be overwhelmed and will need assistance to understand what's available to them. Thank you.
I'm perfectly prepared to content to admit that speech, Deputy Curtis, but of course debate in second reading is on the individual articles and whether or not they should be adopted and not more general points. So perhaps that might have been better for third reading, but we'll leave it as it is. Does any other member wish to speak in second reading? If no other member wishes to speak in second reading, I close the debate and call upon the Minister to respond.
Thank you, sir. I thank the Deputy for her comments. Within the regulations, we do speak about relevant clinicians that will already be working with the people concerned, and I have asked my team to ensure that communications are had with all of those relevant clinicians so that the process is understood by all. And I'd also like to give the Deputy my assurance that one of my priorities is to ensure that all of our benefits are well promoted so that people that are eligible for them do know that they can claim and that those processes are as easy as possible. So at the core of these law changes is that desire to make our processes as easy and friction-free as possible. Sir, I call for the appel.
The appel is called for. I invite members to return to the Assembly. The vote is on the adoption of the articles in second reading. And I ask the greffier to open the voting and members to vote. If members have had the opportunity of casting their vote, then I ask the greffier to close the voting. The articles have been adopted in second reading, 37 votes for, no votes contra, no abstentions. Do you move the law in third reading, Minister?
Yes, sir.
Is it seconded for third reading?
Yes, sir.
Does any member wish to speak in third reading? No member wishes to speak in third reading. I close the debate. Call for the appel, or?
Yes, sir.
Very well. I ask the greffier to open the voting. The vote is on P30 in third reading. If members have had the opportunity of casting their vote, I ask the greffier to close the voting. And the regulations have been adopted in a third reading, 37 votes for, no votes contra, no abstentions. The next item is the draft Highways Law Jersey Amendment Regulations P31, lodged by the Minister for Infrastructure. The main respondent will be the Chair of the Environment, Housing and Infrastructure Scrutiny Panel, and I ask the greffier to read the citation.
Draft Highways Law Jersey Amendment Regulations 2000. The states make these regulations under the Order in Council of the 26th of December 1851 and Article 8A of the Highways Jersey Law 1956.
Minister.
Thank you, sir. So during the build-up to the 2022 general election, the 13 highway authorities became aware of the legal requirement for a candidate standing for election to apply for a licence from the relevant highway authority if they wish to place any election materials on the highway. A candidate for Deputy or Connétable would therefore likely have to apply to the Minister for Infrastructure and to the relevant Parish Roads Committee if they were to place materials on both state and parish roads, in some cases perhaps requiring multiple licences. This requirement was combined with the concern for the safety of anyone placing election materials on or above the highway and the possible impact of unsafe activities on the general public. A set of guidelines agreed by the highway authorities was therefore produced to provide safe standards and practices for placing such materials. The highway authorities deemed the placement of election materials acceptable without a licence, subject to compliance with these guidelines. That was the first step towards the creation of the draft regulations which are before the Assembly today. In the period between the 2022 general election and today, officers from infrastructure have worked with relevant colleagues to review what had been put in place in 2022. It was determined that the guidelines, whilst providing some details of were when and how election advertising can be placed, are currently stretching the law, and that this should be formalised in future. Otherwise, a licence from each relevant highway authority would be required. The draft regulations, if agreed, will accordingly make the necessary changes to the Highways Jersey Law 1956 to enable advertising materials which relate to either an election held in accordance with the Elections Jersey Law 2002 or a referendum held in accordance with the Referendum Jersey Law 2017 to be placed on or above the highway without a requirement for a licence, provided such advertising is compliant with the conditions that will be specified in guidance to be issued under the varies of the subsequent order. Work is currently ongoing in respect of the guidance, and consultation has commenced and continues. The same position would be applied to a parochial election for either a centenier or procureur du bien public, as both of these are also governed by the Elections Jersey Law 2002. An election for any other parochial position, such as a ventenier, constable's officer, or roads committee or rates, would not be affected by this. The current requirement for each candidate to obtain a licence from the relevant highway authorities, which would include a number of conditions applied to ensure the safety of everyone concerned, the candidate, their supporters and the general public, would place an additional administrative burden on already busy officers to process and could incur a cost. These draft regulations, if adopted, reduce the administration burden and facilitate the democratic process in a legal and orderly manner by ensuring there are consistent, fair and safe rules for the placing of election materials. I hope members will agree that it is important that there are some arrangements in place for election materials, as signs can present a safety risk to the public if, for example, they are placed next to important road signs or they are obstructive in some other way. I trust that the proposed solution of removing the requirement for a licence and relying instead on adherence to a code, which is widely consulted upon and sensibly applied, is a practical and proportionate way forward. I move the principles, sir.
Are the principles seconded?
Yes, sir.
Any member wish to speak on the principles? Connétable and Brillard.
Thank you, sir. Really, I rise to speak on behalf of the Comité de Connétable, who wholeheartedly supports this proposal. Clearly, the arrangements in the past have been somewhat woolly, sir, and impossible to manage in a fair and proper way. So this will give, parishes and the police, I suppose it would be, the varies to be able to deal with advertising material inappropriately placed, and I look forward to seeing it in action. Thank you, sir.
Deputy Jeanne.
Thank you, sir. And I arise briefly also as the Chair of the Environment, Housing and Infrastructure Panel to say that we briefly reviewed this amendment and will also welcome the amendments brought by the Minister for Infrastructure.
Does any other member wish to speak on the principles? If no other member wishes to speak, I close the debate and call upon the Minister to respond.
Thank you, sir. And I thank the two members for their comments and also for their support. We have consulted with both parties. So it's important, sir, that we have a level playing field for both candidates and also the highway authorities so that a consistent approach can be taken. So I move the principles. Thank you.
Those in favour of adopting the principles kindly show. Those against? Principles are adopted. Deputy Joan, I take it from what you've said, your panel doesn't wish to call the matter in?
No, sir.
How do you wish to deal with the matter in second reading?
Thanks, Sir. So there are just two regulations which deliver what I've set out in the principles. I therefore intend to move the regulations en bloc.
And are they seconded for second reading? Does any member wish to speak in second reading? I close the debate. Those in favour of adopting in second reading kindly show. Those against? Adopted in second reading. Do you move in third reading, Minister?
Thank you, Sir. Before I do so, I'd just like to thank my officials for their work, the parish officials, the committee de Conatable for their positive comments, colleagues in scrutiny, Sir, and also the law officer and drafter, and I'll move the principles to third reading and ask for the appel, Sir.
Very well. Are they seconded for third reading? Yes, sir. Does any member wish to speak in third reading? I close the debate. The appel is called for. I invite any members not in the Assembly to return to their seats. And I ask the greffier to open the voting. The vote is on the adoption of the regulations in third reading. If members have had the opportunity of casting their vote, then I ask the greffier to close the voting. The regulations have been adopted in a third reading, 42 votes pour, no votes contre, no abstentions. Very well. We now come to the next item of public business, which is consultation and report on pre-sale agreements for land and property transactions, P.34, lodged by Deputy Andrews. The main responder will be the Chief Minister and the Minister for Housing. And I ask the greffier to read the proposition.
The States are asked to decide whether they are of opinion to request the Chief Minister, in collaboration with the Minister for Housing, to conduct a consultation with interested parties regarding the use of pre-sale agreements for land and property transactions, with a view to presenting the findings of the consultation to the Assembly no later than June 2027.
Yes, Deputy.
Thank you very much, sir. I took great interest in the property transaction review report that I studied several months ago. It was a report, in fact, that I was totally unaware of. It was only when I did a bit of digging that I came across it, and I was fascinated by the findings of the report, but also the recommendations. And I was somewhat disappointed to see that some of the recommendations were not followed through. The then Chief Minister, Deputy Gorst, neither agreed or disagreed with some of the recommendations. Now, the first recommendation was one that I thought was a very prudent recommendation, sir. It was requesting that the Minister go away and launch a consultation into the use of pre-sale agreements in a standard transaction process, sir. And there would also be included a discussion about whether a fee should be incurred should one party fail the other in a property transaction, or a prospective property transaction, sir, that ends up being failed. Now, sir, there is, of course, discourse among lawyers and estate agents and also members of the public about what should be done. What should Jersey do? Should we introduce legislation or not? Now, many people, of course, as you may already be aware, have in fact experienced gazundering and gazumping. In fact, Sir, Jersey has had an issue with gazumping. Due to low interest rates, there was more demand in the market. And because there were minimal protections, or the individuals involved in the transaction did not know about pre-sale agreements, or they had been poorly advised, and there was no protections, quite late on, what would happen is once they had obtained a mortgage, instructed their lawyer to proceed with the transaction, the bank would go ahead and conduct a survey, all of which happens to be very, very costly, especially for somebody who is part of Middle Jersey, sir. So to see the counterparty all of a sudden pull out of a transaction when you have spent potentially 5, 10, but possibly more thousands of pounds on a transaction that happens to be failed, I and other members, I'm sure, agree that something ought to be done. This cannot continue, sir. And having engaged with many members of the public, having rectified my politics page ad that was not working for about 18 months, I managed to promote an ad, and I was wanting to hear the voices of those islanders who've been gazumped, or potentially those who've been gazundered. And many people came forward, some of whom didn't really want to speak about it in the public domain. And so it was in the private domain that I was informed about the process that they unfortunately experienced. One where a second buyer would come in late into the process, outbid them, and it was maybe, quite often, a couple of days before the court date. And also you've got to consider, sir, about the chain as well. There are many people involved in transactions. It's not just about selling your property. You also might be involved in acquiring a property as well, sir. Now, just because the panel covered this topic, there were several aspects that I went away and I did a bit of research, and it wasn't really component to what was covered, unfortunately, in 2018 regarding the use of pre-sale agreements. So I just want to now respond to several things that were mentioned in the comments paper. The Chief Minister predicated that I mentioned that it wouldn't form part to every single transaction. Well, in other jurisdictions, there are exclusions, and that would be part of the law. For instance, if it was an interfamily transaction, transfers between related entities, banks selling repossessed property, compulsory purchase, intergovernmental transfers such as those to ALOs, sir. However, in a country such as, say, China, where off-plan sales happen to be very well regulated. I know some people might say, well, it is the Chinese government. However, they do consider things with caution in regard to protecting buyers and also the interests of developers as well. Now, in France, it's probably quite well known that they have quite a robust process as a unilateral and a bilateral agreement where parties can agree to a transaction. And there is a 10-day cooling off period. So in essence, if somebody maybe has reservations about the transaction and they want to put a halt to it, then they can choose to do so. And I think it is very important, sir, that if we are to go ahead with this, that we are open-minded. We are open to exploring opportunities for people. We want islanders to be protected because at the moment what exists is an unethical and immoral practice, and it is legal, sir. It ought to be addressed. What we ought to be ensuring, sir, is that there are greater protections, so there is a greater degree of certainty for people who commence with a transaction, sir. So buyers and sellers, it's not just about having a greater level of certainty, it's also about stipulating clauses within pre-sale agreements, sir, and that should again be defined in law. So for instance, if somebody is part of a chain and they cannot sell their property because somebody has pulled out, then there should be no such fee that is incurred to the buyer of the property who is selling the property to them, sir. And the reason for that, sir, is because there is a genuine reason why they were unable to commit. And I think there should be such clauses in pre-sale agreements to ensure that no fee is incurred for parties, sir. Now, there also has to be defined reasons and legitimate reasons for somebody being able to withdraw from a transaction. In one such case, a friend of mine who was very young at the time, he climbed onto the property ladder when he was about 22, and unfortunately, the property was quite old, and he really struggled to sell the property because about 4 or 5 people who had surveys completed on the property discovered that there were a number of issues, and so the bank was not willing to lend. Therefore, there would be an implication. Had my friend not been able to secure a sale of his property, then how could he commit to the purchase of another property, sir? I think it is sensible, sir, to have that inclusion within a law if one was to be introduced, sir. Now, sir, I'll just go through my notes here. There is an important element that I think ought to be mentioned, and that is, sir, an exclusivity clause. What that basically stipulates is once an agreement has been struck, the seller cannot continue to market the property. I think this is a fair and a reasonable stance, sir. We want to ensure that there is no gazumping. Potentially there could be if somebody is willing to pay above and beyond the price that is marketed, and also in excess of the fee that would be incurred for the seller, sir. So I think that is a pertinent thing to do. I know a number of estate agents, in fact, who happen to be in support of this, sir. One, in fact, happened to contact me, sir. And the reason being is because they knew that this is something that is required. We do need a law, but we need to consult, and we need to consult largely with industry. That means lawyers, it means estate agents, and other property professionals as well. But it's also about exploring the extent of gazumping in the past, because that has been a real issue. There's been a number of people who've shared their experiences of being gazumped, and again, the costs amount to thousands of pounds. There have been a number of studies that, again, are relative to the UK, sir, but gazumping has proven to be a considerable problem, sir. It has been an issue where many people have lost out financially. There was one such study in 2014. 37% of the 1,183 survey participants said that they had experience of being gazumped during the property transaction process. Now, 59% of those attributed this to delays in securing a mortgage. There were others as well who had difficulties in selling their property, and they made up 58% of those survey participants who had experienced gazumping. And recently, sir, a further study that was completed by an independent specialist lender launched a survey, and 2,000 participants took part in the survey, of which 31% of the people who had purchased a property in England and Wales over the last decade had experienced gazumping. Now, that is a considerable number of people, sir, and I would imagine the same thing has happened in Jersey as well. Both the UK and Jersey have inadequate protections for people, and this is an area that must be improved. Now, I know the Chief Minister is saying, well, this should be something for the next government to deal with. But in the response to my written question that I received during the interval, he said, this is something that the next government must do. So why can we not commit to ensuring that this work is done? Why is it a case of saying, no, we cannot do this because we've got our own priority? Surely this should be a priority. People are losing out considerably because of this. It was on the 21st of January 2016 that even the Chief Minister himself said, we need a law for this, because he experienced a young couple being gazumped. And of course, Deputy Luce was also in agreement. Underneath, he commented, I totally agree with you on this. We need a law. I totally agree with both the Chief Minister and the Environment Minister as well. But we cannot just instruct the executive to go away and form a law. It's important that we consult, and we consult properly. I also want to hear the voices of those who happen to be antithetical about pre-sale agreements, sir. It is only right that they have their voice be heard. I know many lawyers will probably fall into that category, sir, but there is a huge number of the public who are in agreement with me. I had over 70 responses to my post, many of whom were people who've been gazumped. And what they were saying is, we need protections. We need protections. We cannot afford to do this. In fact, I bumped into a relative of mine, sir, and I explained to them what I was doing politically because they asked. And I said, oh, yes, I'm looking at gazumping. And then I spoke to my grandfather, and he said, you shouldn't have brought that topic up with them. That was the reason why they, unfortunately, had a very bad experience where they had a bit of a breakdown, and it was that's what triggered it, among other things. And it does do that to people. It does hurt you financially. And also it does inevitably cause tensions within the household. If you've seen your transaction fail, as the case is with one survey in the UK here, 62% of the respondents who were gazumped, they said they missed out on their dream home because somebody gazumped them. I don't think that's really fair. I think something has to be done, and I think it's down to politicians such as ourselves and legislatures in other jurisdictions, not just Jersey, who've got to do more. We've got to be more effective. We've got to be more methodical. We've got to be protecting people. I don't see why there should be a response to the one that is in relation to my proposition, effectively saying, well, this is for a future Council of Ministers to decide whether they should do it. Is it a case of, well, we cannot agree any decision whatsoever if it goes into next term of office? That doesn't sound very democratic. Is this a matter of public interest? Of course it certainly is. We've seen many people, especially Middle Jersey, be hard done by. That's not right. It has to be corrected. And we should be supporting this proposition. We should be launching a consultation to make sure that there are enhanced protections for islanders to put a stop to gazumping, but also to gazundering, because gazundering has been a more recent issue. Because there's been a negative output gap in the economy, people have been finding it very difficult to try and sell their properties. So when a buyer comes along, they're in a very strong position. Even if a price has been agreed, they can say, last minute, I'm sorry, but I'm only going to accept a lower price. And that's why many people who've maybe made a commitment to then buy a property have to then rethink altogether. It's not right. It's not okay. And the Chief Minister, surely he agrees with me that something has to be done. And it should be done before 2027. That is the responsibility of a political executive. How is he going to justify himself when he previously agreed that a law is needed and now he's saying no law is needed? That isn't on. And things ought to change. So thank you, sir. I'm going to propose my proposition and I look forward to hearing members out.
Is the proposition seconded?
Yes, sir.
Does any member wish to speak on the proposition? Deputy Moore.
Thank you, sir. I merely wish to compliment Deputy Andrews on his excellent research and for bringing back to the Assembly a matter that impacts upon many people's lives. Ultimately, we are here to serve the public, not ourselves. And forgive me, but some members of the public who observe this Assembly could be forgiven at the end of today, thinking that we prefer to give officers jobs looking into the positioning of posters for our election campaigns over and above conducting work that impacts on what is widely known and recognised as one of the most stressful times in a person's life, that of transacting or buying or moving home. Sir, I will absolutely be supporting Deputy Andrews in this simple request. I too have spoken to members of the estate agents community, along with constituents who have experienced difficulties in transacting, reaching agreements on the purchase of a home, and I think that this is about time that we start to make progress on this matter and not put it off and kick it into the long grass once again.
Deputy Taddy, you have a question for the Attorney General?
Yes, sir. Obviously, he can answer it whenever he likes, sir. So I apologise that I've not been able to give notice. It's only just come to my mind. Would the Attorney General clarify whether there's anything that prevents currently the use of pre-sale agreements in Jersey law, and whether or not, in his experience, it is something that takes place? If that's not, the latter may be a political question, I accept. But if he's able to maybe clarify what the current position is and what the framework might be currently without this, if this wasn't passed today.
Mr. Attorney, do you wish to offer an answer at this point?
Sorry, I'm happy to do so. Sir, pre-sale agreements are currently available in Jersey law. They are, as I understand it, infrequently used, and they create obligations between both buyer and seller, so that if the buyer, for example, fails to complete, then there is a possible penalty that the buyer may suffer. In terms of how they operate, they don't necessarily guarantee that a property purchase will take place, because if there is a failure to complete, then normally it is agreed in such pre-sale agreements that liquidated damages will be paid. It's a sum of money, rather than necessarily the transfer of the property. And that is because in Jersey law, where it is real property as opposed to share transfer property that's owned by a company, specific performance is not available as a matter of Jersey law. So they are, in summary, they are already available in Jersey, but they are not frequently used for the reasons that I have just summarised. Also, there's an additional cost to using them, and that may be a further reason for not using them. I hope that assists, sir.
Very much, Mr. Attorney.
Thank you, sir.
Very well. Does any other member wish to speak on the proposition? Deputy Meze.
Thank you, sir. Towards the end of her remarks, Deputy Moore spoke of wanting to move forward and not kick things down the road. And I have to say that I think that the principal problem with this proposition is that it doesn't actually achieve what Deputy Moore suggested in principle she would want to see. The reason, sir, that I think the Assembly should reject the proposition, notwithstanding the fact that Deputy Andrews raises an absolutely valid point and valid concern that there will be people out there in our society who that will resonate with, who have been subject to injustice because of those practices. But his proposition has three flaws. The first flaw, sir, is that he's asking for a 2-year consultation. That is excessive. That is way too long to be consulting on what is actually a very narrow point. That brings me on to the next flaw, is that it's far too narrow a point. He's asking us to consult on one part of the process for buying or selling homes, when there's actually probably quite a few other elements of the system that could do with a good look at as well. You know, it's not ordinary when compared to other jurisdictions. In Jersey, to buy your home, you have to actually physically go to court and go through the uncertainty of that process. And if we were wanting to dedicate time and resource onto making the system better for people buying and selling, why would we restrict ourselves to one very narrow part of that? That strikes me to be totally disproportionate, to spend 2 years looking at just one tiny element of the system. And so the third flaw in it is that his proposition asks us to conduct a 2-year consultation without itself specifying what potential solutions we would want to fish for views on. The report is rather non-committal about what potential solutions there might be to this. I mean, if you were to ask for a consultation on making pre-sale agreements compulsory, you know, that comes with all sorts of problems itself, but at least it's an idea for a solution. He's not asking us to consult on that. It seems to be just a completely open consultation, which I don't think would be a very good use of resources, wouldn't be direct, and it's not clear what we'd end up with at the end of it, and either way we wouldn't end up with it potentially for 2 years from now. So I'm sorry to say that I struggle to get enthusiastic about the way this proposition is termed, though it is clearly coming from a well-meaning place and it highlights an issue that some people will face. I think that its principal problem is that it does the opposite of what Deputy Moore suggested, which is that it doesn't take us forward and it does kick things into the long grass. I think that if the subject of the process of buying and selling a home is one to be looked at to make that better for everyone, this is certainly not the way of going about it. And that, sir, is why I will oppose the proposition.
Right, Deputy Constable St Mary.
Thank you, sir. The report accompanying the proposition begins with the words, the Residential Property Transactions Review Panel and its report. I chaired that panel back in two summers ago at any rate, and it is right that one of our main recommendations was the greater use of preliminary agreements. Personally, I find it disappointing that great use is not made of them, and I still fail to understand why it's not common practice. The Attorney General makes reference to cost. One firm of lawyers who does use them occasionally say it doesn't increase the cost. I think another problem might well be the belief that it adds to a delay in the transaction. I do recall that at the time of my presentation report, I drew an analogy between the conveyancing process and the cross-channel ferry service, suggesting that the preliminary contract one was akin to catching the overnight boat, which was almost guaranteed to run, but might take longer, whereas the straight into court on a Friday, not knowing whether you're going to pass contracts or not, was more akin to the quicker service, where weather and other problems might intervene. I'm not quite sure whether the state of our ferry service now merits such an analogy today, but I think members will get my drift. It's always the case that there is going to be a time when verbal agreement has been reached and a binding agreement has not yet been reached. And so during that period, there is an opportunity to gazump or gazunder. And so even with a preliminary contract for sale gone through lawyers, you won't automatically avoid that problem. It will perhaps confine the time within which it can be excised to a shorter period, and that is commendable. Certainly, I do very much favour the idea of a preliminary contract. I confess to, in my earlier life, I carried out more conveyancing than I cared to for a living, and I fled England to avoid that activity. But it was standard practice in English practices to, you have a preliminary agreement, you exchange contracts sometimes over the phone, and you then bring an element of certainty to the equation. And that is a basic problem with the present system, the lack of certainty, which affects and gives rise to possible gazundering problems, to last-minute requests for a further amount to get the deal through, and also, and perhaps not well publicised, the problem that it inflicts on tenants. There is an interaction between buying and selling houses and tenancies. Why would a tenant, or how could a tenant commit to giving notice on his tenancy agreement to buy his house if he doesn't yet know it is definitely to go through? And the converse applies. Someone selling a house is not going to commit to a tenancy agreement until that sale's gone through, and it does slow down the whole process. So again, as other speakers have mentioned, I commend the Deputy for bringing this to public attention. It is still there, and I think can only be solved by lawyers who will be acting in the best interest of their own clients, adopting a better practice. The further point I mentioned, which might be helpful, sir, is that the Environment, Housing and Infrastructure Security Panel, of which I'm a member, is committed to conducting a housing review, and this will fall within its remit, and I venture to suggest that action there might bring a more immediate result than one would by going out to consultation. I haven't yet worked out whether I shall support the property itself or merely abstain, but it is worthy of note, and I hope my comments are of some assistance. Thanks, sir.
Constable St Saviour.
Thank you, sir. I think it's fair to say, sir, that the housing market at the moment is slow. Money is tight, everyone is feeling it, And lots of houses now are being sold, as has been said, in chains, that people have to sell their own home before they can buy another. And you could have the situation where 3 couples turn up at the Royal Court, and if one couple backs out for whatever reason, the whole thing falls apart, which is extremely stressful. As has been said, getting married and buying a house, I think, are the 2 most stressful things in life. I'll leave members to decide which one is the more stressful. But I do support the motives behind this. It is very stressful. It's the most important financial decision that most people will make in their lives, and I think it needs our support, sir. But I would agree that 2 years is far, far too long. Thanks, sir.
Deputy Miller.
Thank you, sir. So I don't support Deputy Andrews' proposition. And I feel slightly conflicted about that because it would take us to a very significant degree closer to the Scottish system, which I would normally say is always worth consideration. And while it is always worth consideration, it does not address some of the problems that the Deputy is seeking to suggest. In Scotland, when you make an offer, you make an offer which may be several pages long with several conditions, terms and conditions of sale. The seller will then do a letter back with their terms and conditions adjusting your offer. That can go on for quite some time. You could have, even in a very simple case, you can have a missive, you can have an exchange of missives that form 2 letters. They can form 6, 7 or 8 letters depending on the nature of the property. They also create a number of legal complexities which I would imagine would arise here in terms of, are there conditions in the pre-sale agreement that you want to succeed after the purchase? And certainly the Scottish profession spent a very long time mulling that over some time ago. The biggest issue I have with this is it will undoubtedly add to cost of conveyancing. If we're asking our property lawyers to start doing an exchange of letters, offers and acceptances, it will become difficult, it will become protracted, and it will add significantly to the cost of conveyancing. The contracts will only agree that people recover their lost costs. It's very rare to enforce a sale of real property, very limited situations in which a sale of real property can be forced by the courts. It also won't stop gazumping. I'm not sure that is a big issue at the moment, because, for example, if the buyer's lost costs in a gazumping situation are £5,000 and a new buyer is offering £20,000 or £30,000, the seller is still ahead on the transaction. It doesn't address the emotional upheaval of losing the home that you want to move into, and it certainly doesn't address any issues around chains. I agree with Deputy Mezek that there is very much more we could do if we're concerned about property transactions in Jersey. There is very many more things we could do, and we just have to cast our mind to the fact that I believe our main law on property is still the 1880 law sur la propriété foncière, and part of our property issue is that many of our laws are in French, so we could certainly be considering some of those aspects before we start adding to complexity and cost for very limited real value. So I don't support the proposition for those reasons. Thank you.
Deputy Tadier.
Thank you, sir. I'm pleased to speak after the Treasury Minister, but also the Constable of St Mary's in his scrutiny capacity, sir. Now, I'd like to take a slightly different tack on this. I don't think we're here to decide whether or not the proposition is perfect, whether we would have worded it in such a way. I think there's a high level of agreement here that Deputy Andrews has identified a genuine problem, and it's a problem that I've been aware of for a long time. Long before I was a home buyer, so to speak, I had lots of people come to me in my political role to tell me about the problems that Deputy Andrews has been telling us about. It's not the first time we've heard them in the Assembly either. And so, you know, one of those examples that we don't necessarily think about are the consequences, not just for the home buyers or the sellers, but actually for all those services that are related to that. So, you know, I've had removal companies say to me that how mad the whole system is, not just the potential for gazumping or gazundering, but the fact that, you know, we only have one day where transactions go through the courts. And what happens if a transaction doesn't go through for whatever reason? People have often booked delivery companies, removal companies, months in advance, especially during the busy transaction periods. And of course, this then throws that into question. And notwithstanding other services that might be provided to new homeowners as well, who are looking to move in and maybe do small jobs, bigger jobs on their new home. So I think it's a question which is understood, a problem which is understood. And I suppose I take off my party political hat, and I'm not a member of government, by the way, so I don't have any reason to necessarily support the ministerial line in this, and say that surely at some point we've got to cut Deputy Andrews some slack in this whole issue. I think, notwithstanding some of the propositions he might have brought in the past, which I don't think I've been able to support, I think he does identify an issue here. So let's start first of all by this question of 2 years is far too long for a review. Well, I don't think that's what Deputy Andrews is suggesting. He's not saying that it should be a 2-year consultation. He's simply saying that the consultation findings should be presented no later than June 2027. So that gives any future government, if it ends up being the work of a future government, time to bed in and consider that. But there's absolutely nothing to stop the current government looking at this issue in any way that they want to. And similarly, and quite rightly, I agree with the comments that have already been made, is that simply looking at pre-sale agreements for land and property transactions as a way of resolving this actual problem is probably not going to be a sufficient solution if it's workable at all. But I think in going through that process now, I think ministers will actually be able to determine what the issues are, the scale of the issues and the extent of those issues, and the extent to which pre-sale agreements might be used. So the Attorney General has told us that there's nothing to stop pre-sale agreements, that there's not a big take-up for them at the moment, but it will certainly enable those conversations and the fact-finding to take place. But I think all of those other questions that do need to be looked at. So, for example, why is it that transactions go to court on a Friday? You know, I don't think the consultation will look at why we call the Friday sitting the Samedi court, because certainly by my French, Samedi means Saturday and not Friday. But why do property and land transactions need to go to court at all? You know, why does somebody need to turn up to court in a suit and make an oath before God when they're buying a house or a property? Is that 21st century? Does that need to happen? I'm not sure if that does need to happen. Does it need to go to the Royal Court? Does it need to go to, could there be a different body that it would go to? If I buy a car, I don't need to go to court to buy a car, and I've never been gazumped or gazundered when I'm buying a car either, but I'm not saying it's exactly the same thing. Of course it's not. I was actually quite interested to hear about the situation in Scotland, because I noticed, I was reading recently on one mortgage provider who talks about gazumping and gazundering, and I must admit that I'd never heard of gazundering before. I always used to think that a gazunder was another name for a chamber pot, sir, something that goes under the bed. But apparently it's a term for that can be used in this context too. And also gazumping, as I understand it, in Jersey, isn't simply the case of somebody coming in with a higher offer. It's actually a case of, perhaps the seller saying, I'm not going to sell this to you unless you give me a higher offer. So I think it's important to establish exactly what the problems are that are being identified here. So my, and I do notice also this particular mortgage seller does reference Scottish law requiring conveyancing to take place to stop gazumping, and so that it's going to be much less common in Scotland than it might be in, say, England and Wales. So on this occasion, I would like to give Deputy Andrews a chance and say, actually, it may well be that ministers need to come back a lot quicker than 2 years. That's fine if they want to do that. I think ministers should look more widely at this issue and identify in quite a quick turnaround what the issues are around property transactions, what it is that can be done to resolve them, indeed what government's role, if anything, should be in that, and what the market could do, what estate agents can do to try and make the passage smoother, to try and make these practices less common. And I think that actually we need to be building consensus around this issue. So I would simply put it back to ministers. What's the worst that can happen in supporting this? By all means, you know, if you want to go over and above in terms of the timescale, making it quicker and what you look at, by all means do that. I also accept the fact that this is something that scrutiny could do, but certainly I know that from my scrutiny panel's perspective, we've got a lot of work coming up. So I would ask ministers to really consider whether their resistance to this is justified and whether they can simply agree to adopt this so that we can all move on and wait for this report to come back in quite a short order. So thank you.
Very much. Deputy Chief Minister.
Came round quickly, sir. I mean, the previous speaker highlighted some of the complexities of the property market, and the council ministers are mindful of the stress and financial cost at the failure of a property transaction that a property transaction can cause to the vendor or the purchaser. So fortunately, most transactions, as the proposer has pointed out, proceed without any problems. So the benefit of applying pre-sale agreements may be limited. So that's not to say it shouldn't be considered, because I support the principle of measures that ensure smoother, more cost-effective property sales, especially for young islanders. And that's at the heart of a lot of the work that the Housing Minister is leading on. And whilst pre-sale agreements can provide certainty to the parties, they come with a level of complexity resulting in additional cost, as well as potentially lengthening the time it takes to undertake a transaction. And of course, vendors and purchasers can voluntarily enter into pre-sale agreements now, which can help them mitigate the risk. So the opportunity to make use of them already exists. To ensure successful completion of a transaction, we would always urge that due diligence is undertaken at each stage of the process by all parties, and that estate agents and lawyers provide good professional service and advice, and are always looking to improve upon that. It is unclear what the proposed consultation is asking for, and whilst I know you could say, well, the overall question is, should we make compulsory perhaps some form of agreement, it's unclear to that. Whilst it notes that the lack of data around property types and sales that are supported by a pre-sale agreement, this proposition does not provide any clarity on how a consultation would resolve this, with an expectation that such a consultation could inform guidance or legislation. And I do think it's important that we get the detail right and consider how we're going to do this before we consider any new layers of regulation or legislation. And a consultation such as this, which is unclear in its aims, may send poorly timed and unconsidered signals to the current market, where transaction levels are low, while we start to see a recovery from the previous period of unsustainable growth. The proposition does not wish to see pre-sale agreements used in all residential property transactions, as Deputy Andrews explained in his introduction, but considers that this should be where there is a delay on completion. There is a difficulty of determining what would constitute a delayed transaction, and this approach would risk creating a two-tier transaction process in the market, with some transactions needing pre-sale agreements and others not. As Councillor St Saviour also mentions, there's often a chain, so there's complexities that pre-sale agreements have in a chain, where some of the chain are subject to them and some aren't. So it's difficult to predict activities such as gazumping and gazundering. So to prevent the practices, pre-sale agreements would need to be applied probably all transactions to avoid that. I think there is a merit in considering the wider use of pre-sale agreements and in reviewing property transaction processes generally. And I think that's an important piece of work for the government, whether it's this one or next one. However, the complexities that surround modernising the property transaction process and the review led by the Deputy of St Mary, it actually published in March 2022. I mean, it's quite a hefty document. A lot of work went into it, but it does highlight that. So I think it would be more prudent to approach this issue in a more comprehensive and planned way, rather than being bound to undertake a consultation with unclear objectives that would divert time and resources that are focused right now on helping more islanders with the cost of renting, the cost of purchasing, and the key priority area of work that we're leading on in this government, which is making housing, affordable homes more accessible to islanders. That's where we would like to focus our resources, and that's why we're suggesting that we continue to do that, use our resources to continue to improve availability of housing to young people, and suggest that the next government might like to pick up on this work, sir. So I would just like to ask members to, well, first to thank the Deputy for bringing it, something he picked up on a social media post I posted 9 years ago. So well done for your perseverance of trolling through 9 years of my social media posts. I think you almost deserve a vote just for that. But on this occasion, I'm going to ask members not to support the proposition. Thank you.
Thank you very much, Chief Minister. Deputy Gardner.
Thank you, sir. Actually, Deputy Tadia delivered most of my thoughts, but my speech probably will be short. I would like to ask members to reflect and answer a question. As Deputy Tadia said, and answer in your heart. As Deputy Tadia said, do we have a general agreement that this is the problem that was raised for years and needs to be resolved? And I think the answer is yes, at least in my mind. Do our young families and not young families, buyers and sellers lose money because of the failed transactions at the last minute? And as corner tab of Sansevier said, there are chains and money is tight. So if actually the young people or young families or first-time buyers or anyone else that we are trying to support to get on the property ladder facing losses because the transaction didn't go through, yes. Did they experience stress? Yes. And would it be helpful for them to have in place pre-sale agreement to ensure that there is a stability and this is certainty? Yes. And I'm a bit, where I find the comments from the Chief Minister and the Housing Minister challenging. Because when the backbencher bring the proposition with clear dates, with very clear what the backbencher would like to see and how it should be delivered, the response from the executive, it's too constrained, we cannot do it in this time, we cannot do this, we cannot do that, we see different way of working. Now, Deputy Andrews, I think, learned from several lessons and from what's happened, and he actually saying, if members would read the proposition, pre-sale agreement, land and property transaction, presenting to the states no later than June 2027. He doesn't say it needs to take 2 years. He's just giving an option not to be told that it's too tight and we cannot deliver within the time. It's over 2 years. Chief Minister left, but actually I would like to tell to the Chief Minister, follow Chief Minister's speech, would it be an opportunity to show leadership and actually said we can deliver? And there is no instructions how consultation should progress, what should be included or not included in the consultation. We know that pre-sale agreement is one of the items that important to be included in the but everything else that Chief Minister mentioned that important to consider, it's open. The Council of Ministers can include this in the consultation. They can decide to do this consultation now and can decide based on this consultation to bring a proposition to the states. It's all in their power. So as Deputy Tadia said, I really, really struggle to see why this proposition that given an option and actually dealing with real outcome that islanders raised with us for years. This is important for islanders, not maybe for everyone, but somebody who's thinking about buying a first home. It is important for them, so maybe we'll do something that's important for the islanders, and I'll be supporting Deputy Andrew.
Does any other member wish to speak on the proposition? Joseph.
Thank you, sir. I commend Deputy Andrews for once again trying to bring a proposition to meet the absolute legitimate expectation that many people, dare I say it, of Deputy Andrews' age are feeling that they can't get onto the property owning ladder. They see no hope, and we've heard Deputy Andrews on a number of occasions bring forward propositions to this Assembly, and whilst we speak quite fairly regularly, what I am astonished to hear from him is that, notwithstanding the fact that he lodged this proposition, he has not had a single discussion on invitation by a minister about his proposition, not one. We talk only in public now up against the cross of the barrier between ministerial and non-ministerial government. And I'm sorry about that, because Deputy Andrews is deserving of respect and support in advancing what he is saying. It's not only the concern of his age group and others, it's the concern of all islanders about the state of the housing market. And of course, he's absolutely right that in the heady, unbelievable days of the high house prices escalation, gazumping was absolutely a real problem. And now, with the housing minister's comments that we need to see further corrections, we've already seen a 12%, we've seen the biggest fall in property prices ever. How low is it going to go? How low does the minister want it to go? I don't think we know. Government can say is speaking with odd and mixed messages. I've heard comments in this speech this afternoon, sir, our priority is getting people into home ownership. Well, I sound like the little boy in the crowd where the emperor's got no clothes on, sir. The reality is that if you don't sort out the supply of three-bedroom houses, which I've said, and you'll repeat me, this is unfortunately a repeated remark that I say lots of times, sir, because it's true, with the Bridging Island Plan having failed to put in place the proper amount of housing land, whether brownfield, government-owned or greenfield land, for the amount of three-bedroom houses that the islanders need, notwithstanding the increase that immigration has fallen, we will have a deficit. And nobody speaks about the elephant in the room, which is the supply and demand. And Deputy Andrews is absolutely right at the moment. You've now got the incidence of not gazumping, but gazundering, as prices are on the decline. And you can almost understand, sir, if I may say, why it is that you have these imperfections and these extraordinary situations where a property is agreed for a sale and then people back out. Either because they can't, because the financial situation is quite as bad as it is, and it is absolutely terrible at the moment. Let me be absolutely clear. There isn't the resurgence, I heard the Treasury Minister, but there isn't the resurgence in property transactions that was said at all. And life is also, I'm going to bring back to the Assembly, sorry sir, I'm going to bring back to the Assembly the debate on a surcharge. I've had the 3 months of cooling off period, and we're going to have the debate about surcharges again. I'm still smarting from the fact that the council ministers brought forward a reduction of 2% and it managed to get thrown out. I wanted nothing. So we've got to deal with that, sir. Government creates markets and shouldn't intervene too much, but should let the market work well. And that's what housing supply and housing purchase and sale is. It's the most important asset that people will get. And of course, Deputy Andrews will know of the many families that will feel aggrieved if they basically aggrieved something, if they've aspired something all their life and that dream is taken away because somebody's gazumped them in a rising market. There are obviously hundreds of islanders that they're losing hope. It's one of the reasons why people are leaving Jersey, sir, and it pains me. But what pains me equally is the lack of communication between ministers and backbenchers about what we're doing for the people that we all represent. There's no communication with Deputy Andrews, I understand, at all. Not even a telephone call, an email to say, we're thinking of making this comment, Deputy. Would you like to come in for a discussion? Or do you not understand this? Or we've got this point to make. Nothing. It's like a them and us in this situation. And for the public that will hear, yes, it's really like that, sir. I say that because there is no communication, no teamwork across the ministerial divide. And I lament this and hope that it changes. It's the reason why I have to irritate you, sir, and ask questions about meetings that don't happen. Sir, what I would say is, having had the property and building and things like that as being central to some of my time in this place since 1999, I would say that gazundering and gazumping happens when markets don't work well, and I would say to the Deputy and to ministers that they really need to get a grip and deal with the supply side, because that's the problem. And Deputy Mezek, he's spoken, he's the housing minister, but I'll show him, because I've got them off confidential.je. It is true that we're selling more social housing, 3-bedroom houses that we're creating, and it's not good enough. Now, proposed pre-sale agreements could create some certainty. I was very struck, sir, having unfortunately required to be involved in a flat sale in London, to expose the Treasury Minister spoke to the Scottish system. I first of all want to put a compliment out to all our lawyers and conveyancers out there, because they do something. They were a bit of a rough ride, sir, and I know we took away the scale fee when the competition law came in. I thought that was going to deal with alcohol pricing fixing as well, but never mind. The competition law did away with the scale fee. That meant that the scale fee that lawyers got to basically fund what they don't do in the UK or many other places, they guarantee title. So when they appear before you in the Royal Court, sir, if you're there, or your deputy, then they are effectively agreeing to a contract between two parties which the state has got nothing to do with. That is very different in the UK, where the land registry guarantees title. Our lawyers are guaranteeing title. If you don't get the right title, sir, you can sue your lawyer. So there's a lot of issues in Jersey which are in some ways brilliant, and I think it was Deputy Balash who, when he was bailiff, moved the language from the French language to the English contract, because unfortunately a lot of people don't speak French, and they were basically raising their hand on a contract they couldn't understand. Well, now it's in English, but we can go further, and I commend the report given a number of years ago by one of the panel. I hadn't read it for quite a long time, and there's clearly an opportunity to do some improvement in the way that the most important purchase in a family or an individual's life happens. There's a lot of, if I may say, tradition associated with coming to the Royal Court, and maybe we need to look favourably on our brilliant certain conveyancing system, because we've got tricks from the past of the Norman era which are absolutely so certain, that give people such certainty in terms of a relief, tour d'échelle, and all the other things that you get translated in the English language. We actually get title, which is really of good quality, and it's guaranteed by our lawyers. That's really good. We don't want to throw that out, and we want to just simply, as we always do, or we should do in Jersey, is improve things. Is passing a contract every Friday really okay? No, it's clearly not. It's a bit silly. You can do flats every day of the week because it's a share transfer, but you can't do a property transaction. I agree that the Friday deadline actually makes transactions happen, particularly when stamp duty changes or otherwise. But that's good, but effectively we need to modernise it, sir. And I would also say a cry out to all those conveyancers who are not very busy at the moment, sir, because the amount of properties going through the market is not very big, that there's a lot of really clever conveyancers sitting in law firms with not a lot to do at the moment that could, with a bit of help and a bit of government support and a bit of leadership, could actually help to modernise our excellent but somewhat antiquated system of contract exchange into a modern digital system. We heard of the council ministers heard of digital and e-contracts and everything. We can go digital. It's very difficult to find out who owns a property in Jersey, sir. You have to go to the registry, and it's very difficult. And actually, I'm in favour of full transparency for the property market, where you can go to a website and see who owns what and all the rest of it. Fundamental. It's really important that people understand what the transactions are, and who owns stuff and what it's going through at. And we've got nothing. We're basically pretty antiquated. So I would use this government inflicted period of stagnation, because it is stagnation and it's falling and it continues to fall, and there's a lot of islanders that are really worried about this, to actually use that time, because you can't build overnight and you need to get building, because we really do, but I would use that time to use constructively those conveyancing firms and those individuals to actually look at our whole system of buying and selling, including a pre-sale agreement. And clearly there's some refinement. As the Constable of St Mary said, our system of transactions in other places, compared to other places, I was very struck with the UK system, where there's a questionnaire that you exchange, Law Society. There's a very structured arrangement that you have, which just simply doesn't happen in Jersey. And so there's a very uncertain situation, I think, that where you don't have, if I'm wrong, I see the External Relations Minister is frowning at me, I don't think you have that system of certainty of questionnaires that you have. So there's actually some improvements to Deputy Andrews, which I would have done if I would have been a minister. I'd have brought Deputy Andrews in and said, look, this is how it works. Going to come and see the conveyancing team. This is what we should do, and actually come out with a win-win. Because there are win-wins that are possible, not win-losers. And when backbenchers are treated like losers, and the council ministers would publish comments and basically say, no, we're not doing it. Does the council ministers really want to treat backbenchers in this way? No, I don't think so. There's an opportunity to do something good. I urge members not to have the clarion call from the council minister say no, but to say yes, but yes, we can improve it. And I don't think Deputy Andrews said 2 years. It's not mandatory. It's a request to the council minister to do things not mandatory. So let's have that as a reason for doing it. And let's support Deputy Andrews, because we all know, I think all members will be aware, that our system of exchange of contracts in Jersey needs some modernisation. It needs some modernisation. So let's do it while the property industry, and there's lots of people not doing very much, because we can improve a system. And so hopefully when that future day where I know that supply and demand will be excellent, and we'll have people having aspirations to get into the property ladder, we'll have an administrative system which is not simply somewhat of a relic of the past, albeit with absolute brilliance in it. But it needs to be e-based, digitally done. It needs to be, I know people like turning up to your court on a Friday, sir, but we can create some other celebration for them having got into the home ownership situation. So I would support Deputy Andrews, and I hope members understand what I'm trying to say. Thank you.
Deputy Scott.
Thank you, sir. I'm standing more in response to the previous speaker, who made certain allegations about the Council of Ministers, suggesting that there isn't any kind of collaboration between the ministers and backbenchers on the basis of what he suggests is a single incident. And I think it's really unfair to suggest that this is a general thing that goes on. on the other hand, I have been a backbencher and I have felt the same way when the previous speaker was in the council minister, so I have some sympathy there. But what I find is getting particularly confusing here is that there's some discussions about the value of a free market and also the desire to help the young. And one of the signs, I think, of a change in market is this thing, this gazumping and gasundering. And we've been talking about how to help younger people buy properties, and gasundering is actually a feature where a market's falling. And so one might think it's very annoying for the person who thinks that they've got an actual deal to then have somebody say, well, in fact, I realised that I probably could pay less for your property. But I do think that actually the bring of this proposition supported the increase of stamp duty for that reason. So in terms of what we're really trying to achieve and whether that works, I just don't see that that's really been identified, even in terms of having this consultation. What will, even if you brought agreements to sale, will that actually reduce it? Where's the evidence elsewhere? You've got to look there, perhaps more so than within the island. Because if you look at the transactions where sale agreements already are being used, how can you actually analyse whether they would have, the sale would have taken place or not if they hadn't been used? So I think the bottom line here is just perhaps the general point has been things like the value for money, which I think has been something that's been important to quite a number of state members in terms of standing. Also, putting this whole thing in context, I mean, I've actually been trained in conveyancing in the UK and in Jersey, and I've actually compared the two systems. And one thing that really strikes me that is a feature in Jersey that actually is a general disincentive to, because there's all manner of reasons why even if you have an agreement for sale, the transaction still may fall through in terms of searches and what comes up in any event. But we're actually a small island and you have to look people in the face. And that's not a feature of many jurisdictions in which you have agreements for sale. So I just thought that I'll throw those thoughts into the pot as members make their deliberations, but I really didn't feel I could just sit here and have suggestions made about the council ministers and their attitude, as it were. I believe that often the council ministers have sought to speak with people bringing propositions, and indeed with the previous speaker himself, that was actually has been mentioned. So I do believe that's all I'm going to say on the subject. Thank you, sir.
Does any other member wish to speak on the proposition? No other member wishes to speak? Deputy Balash.
So I have some sympathy for Deputy Andrews, both in his aspirations and indeed for the reasons given by Deputy Ozuf, because it seems to me a pity that ministers did not respond to this proposition by inviting the Deputy to come and discuss what he really wanted to achieve. My problem with the proposition is that it seems to me that it is taking us down a blind alley. And the reason for that is that the law already allows for the existence of preliminary agreements of sale. Indeed, when I was in practice many years ago, it was the custom for sellers and buyers who had agreed on a transaction to complete a preliminary agreement of sale. It was an agreement which recorded the agreement of the buyer to buy and the seller to sell under penalty. And the penalty was usually fixed at about 1/3 of the value of the property. It was an agreement of sale under penalty because it is not possible, as the Attorney General explained to us, it is not possible for there to be specific performance of an agreement to buy land in Jersey. The reason for that is that when people convey land, they both appear before you, sir, in another place, and they take an oath. And no person, obviously, can be compelled to take an oath. And that is the reason why that it is not possible to have specific performance of an agreement agreement to buy and to sell property. That is why it was the custom for agreements to record the penalty, which would be forfeited by the person who declined to complete the transaction. So what is this proposition going to achieve? It doesn't seem to me that it's possible to compel people to sign a preliminary agreement of sale. One party might want a preliminary agreement, the other party might not. One party might want to have a survey carried out before he commits himself to a purchase. Another party might, for different reasons, not want to commit to selling until certain contingencies were fulfilled. So what is this going to achieve? Deputy Joseph spoke very interestingly about the introduction of digital transactions in land and completely turning our system of conveyancing upside down. But that's a different matter, and that's not what this proposition is all about. This proposition is to ask for a consultation with interested parties regarding the use of pre-sale agreements. But however much one may think...
Are we able to say who's got their microphone on? I'm sorry, Deputy, please continue.
So, however much one may think that it is desirable to have a preliminary agreement of sale, and as I say, many years ago it was the practice, it doesn't seem to me that it's something that can be enforced upon the public. So what is the Chief Minister going to do? He's going to carry out a consultation, but to what effect? I don't think, so, as I say, that this proposition really leads us anywhere. It takes us down a blind alley, and I'm afraid that I cannot support it.
Speaker, for a point of clarification.
You give way, Deputy Barsh, for a point of clarification.
I'm just wondering, I don't understand. I'm looking at Deputy Balash is a lawyer and knows about all of these matters. The Deputy has brought forward a proposal that is in the wording of a report done by another group of people that said a pre-sale agreement should form part of the transaction process. The Deputy said that you can't force somebody to court, but you can pay liquidated damages. I don't understand why you can't have a pre-sale agreement that has liquidated damages. Have I missed something, or should I ask for legal advice?
I'm sorry if I didn't make myself clear. You can, and that is what a preliminary sale agreement in Jersey does do. It requires the parties to complete the transaction, or if they refuse to do so, to pay damages, to pay a stipulated penalty.
Just confused, sir, in to say that it's not possible to do what Deputy Andrews said, because the Deputy has said you can do it, but it's not this, it's that, which is penalties, not forcing somebody to court. And so to vote against it, being on the basis that you can't do it, is not quite right.
Well, I'm afraid that's second speech. My understanding of what Deputy Barsh was saying is that there is no point to doing it, was his argument, because what it will look at is already there. That, I believe, is what he is saying. Is that correct, Deputy? Yes, very well. Does any other member wish to speak? If no other member wishes to speak, I close the debate and call upon Deputy Andrews to respond.
Thank you very much, sir, and I must thank all members who've contributed to this debate. The Chief Minister, in his comments regarding my proposition, never defined what the consultation would look like himself when he was the one who predicated that we need a law. He never elucidated what components would comprise of, within the law, and it was disappointing that he didn't do that. If he felt that there was further need to elaborate, then he should have said so, and he should have then defined what he meant by that, but he didn't. In terms of the response to Deputy Mezek, it is not a 2-year period. It is within that period that the work should be commenced with. If it takes 3 or 4 months to launch a consultation and to come up with the report being finalised, then good, and I think the sooner the better. But as Deputy Farnham said in response to me, when I asked him an oral question, he said, I think this is something that we need to do. Unfortunately, with the quietening down of the housing market, it is not such a priority, but it is something I think the government or the next government needs to look at. I think the words, I think the government is the incumbent government, and also when we're looking at the next government needs to look at. So he is acknowledging that this is an area of complexity. It is an area that has to be addressed. And he is saying no. I mean, quite simply, what he could have done is he could have said to me, look, can we have a discussion, as Deputy Joseph said, and let's really speak about what you're trying to do with your proposition, sir. For me, I think it is absolutely essential that we look at the feasibility of making sure that if a transaction is part of the standard transaction process, that it is mandatory, sir. The reason being is we want to ensure that there is greater certainty in transactions. We want to actually see more transactions go through instead of transactions falling through. And that is also something that isn't really part of the figures that we see on Statistics Jersey websites. Between 2014 and 2022, I think it was, transactions numbered somewhere between 1,250 to about 1,850 transactions per annum. Unfortunately, transactions have dropped below 1,000. That's about 700 transactions, I think, for the year 2024 or thereabouts. And so, of course, there is a real issue with gazundering. However, in the past, it has been an issue mainly to do with gazumping, and hence the reason why property prices have gone up so much, because there have been so many buys. And as Deputy Joseph alluded to, it is a supply and demand issue, and it's about getting that balance right. Otherwise, there will be issues either with gazumping or gazundering. I want to thank members who have stood up and who have supported me. I think they can see there is a genuine need to ensure that islanders' voices are heard, because we don't have any data about gazumping, nor do we have any data about gazundering, but we do have data in the UK, because the UK government, alongside a number of different agencies, has collected data to that effect. But here, we haven't even started yet, and I think it's about time that we need to look to see how severe of an issue was gazumping during the period when we had lower interest rates, but also about the current market conditions as well. That's what we really need to be looking at, because I've had one friend, in fact, who wasn't actually gazundered, but he was gazumped, and he lost somewhere between £5,000 and £10,000 at the tail end of 2024. And of course, it has impacted him, it's impacted his partner, and there are many people who have very much similar experiences, and it's something that isn't really spoken about. It's not the sort of thing that you are going to go and tell people. It's an inconspicuous issue, and it happens probably more often than not, sir. So I think I have made the points clear when I made my speech. I think it's important, if a consultation is to take place, the Chief Minister has to sit down with his officers, and it's about looking at the transaction process from start to finish and looking at how a pre-sale agreement would best fit into that process. We want greater certainty for islanders. We want islanders to feel protected. What we don't want to see is this continued level of uncertainty that happens as part of the transaction process. As I've stated in my report, many transactions don't include a pre-sale agreement, so many people are vulnerable. You might end up the night before hearing that your counterparty in the transaction has pulled out and you've incurred all of those fees. That's not a pleasant experience, and I do sympathise and I feel very sorry for those people, sir. And that's the reason why I want to try and prohibit that from happening as much as possible. It's not to say that you are guaranteed to see the transaction be completed. There are a number of circumstances where a transaction may not be completed. As I alluded to, for instance, you might not be able to have the bank lend to you because there are issues with the property, and that is the seller's issue to try and resolve. And that happened to my friend, actually, as I say, about 10 years ago. But I think if we are in a position of wanting to do things on behalf of the public, it is a matter of public interest, then what we need to be doing is we need to be voting that pour button. And I urge members to support me and to support my proposition. Thank you, sir. I call for the appel.
As called for, I invite members to return to their seats. The vote is on P34. And I ask the greffier to open the voting and members to vote. If members have had the opportunity of casting their vote, then I ask the greffier to ask if you to close the voting. The proposition has been defeated. 12 votes pour, 32 votes contre, 1 abstention.
Those members voting pour, the Connétable, St Clement and St Saviour, and Deputies Dublé, Gardner, Moore, Ozef, War, Miles, Renouf, Jeune, Andrews and Tadier.
Very well. The next item is French National Identity cards as valid travel documentation for French citizens, lodged by Deputy Balash. The main respondent is the Minister for Justice and Home Affairs. There's an amendment lodged by Deputy Ozef. Deputy Balash, are you accepting that amendment?
No, sir. I think there should be a debate on the amendment, and so I'm not formally accepting it.
Very well. Then that will be dealt with separately. I therefore ask the greffier to read the proposition.
The States are asked to decide whether they are of opinion to request the Minister for Justice and Home Affairs, subject to the existing safeguards to protect the integrity of the common travel area, to maintain the scheme whereby French citizens can use a valid French national identity card to travel to Jersey.
Deputy.
So I'm grateful to the Minister for Justice and Home Affairs for indicating that she supports my proposition, and I will therefore be brief because the more interesting debate, I think, will take place around the amendment lodged by Deputy Ozef. I will, however, say two things. The first one is that every country, and Jersey is no exception, has a right to defend its economic interests. It is perfectly legitimate, and indeed I would say it is our duty to protect the interests of our visitor economy. If the boot were on another foot and the United Kingdom had to decide whether or not to protect its economic interests, it would not hesitate to do so for a nanosecond. The second point is that in international arrangements, fairness counts. Because it is a member of the European Union, Ireland admits French travellers on a national identity card. We are geographically much closer to France than to the UK, and it makes sense for economic reasons for us to do likewise. Both Ireland and Jersey are in the common travel area. Why should we not offer this concession when the position in Ireland is of an order of magnitude more risky to the integrity of the common travel area? The Home Office well understands Jersey's position and also understands that there is a right to maintain the scheme whereby French citizens can enter Jersey on production of a valid national identity card. It is not a threat to the UK because of the considerable administrative protections put in place by officials in the Immigration Department. Indeed, I would say that we have proved beyond doubt that the scheme works. I move the proposition.
Is the proposition seconded?
Yes, sir.
There is an amendment to the proposition offered by Deputy Joseph, and I ask the greffier to read the amendment.
Page 2. After the words "to maintain," insert the words "and extend," and after the words "travel to Jersey," insert the words "to short stays of up to 72 hours."
Deputy.
Thank you, sir. Well, I get myself into some difficulties, don't I, sir? Deputy Balash brings forward a proposition which I absolutely don't, I have no understanding why there is any doubt whatsoever that we don't continue with. I see an opportunity because I was the External Relations Minister. I thought that I was responsible for helping ministers with their international affairs. And during my tenure as External Relations Minister, I held discussions at the senior levels in London and Paris and regions. And then, as members will know, I was then out of office, and I don't really know what happened after then. But I know what I did. And I know what Jersey's arrangements, as so eloquently put by Deputy Balash, are. The Minister's predecessor, Deputy Miles, and I worked on this, and she obviously then dealt with it when I was hors de combat. And it was absolutely the right thing to do. And the minister who sits next to her, the Minister for Sustainable Economic Development, who I know is as equally supportive of the reinforcement of French affairs as I and other members, French language, all the rest of it, knows that we have a huge amount to offer to French visitors, knows that there is only 50% of French people who have passports, and so would, in an ideal situation, undoubtedly want to have longer stays. It's borne out by the facts that with the numbers of people going, and they've been quoted in Deputy Balash's report, I put them, when we lost the ability, and I don't know why we didn't use the powers that we do to have it, because I've looked at the legislation, and it is confusing, I agree, that immigration, that the word order is actually primary legislation for effectively the legal instrument that is the minister's being asked to effectively amend by these two propositions. It is a legal instrument of a ministerial order, which isn't made as an order, but it is a legal, the Attorney General, if necessary, if members want to ask, the Attorney General can explain it. I want to just deal with the reality of the situation. We saw a welcome explosion, a massive turn down in a visitor economy. If members will recall, in 2022, we were seeing almost a complete absence of the babble of French on our roads. on the King Street and Queen Street. We saw a catastrophic fall in day trip, and of course the numbers of day trippers. We don't only have day trippers, we have people that want to stay overnight as well. So the statistics that are used are, that have been presented are not saying the whole picture. We like day trippers, but we like, I'm sure, people who come and spend money in one of our excellent hotels or restaurants and go and visit, particularly with the timings of our ferries, and I commend the arrangements, although there is always teething problems. We've now got the prospect of really good ferry operations in the long term in Jersey, and we need to make it as easy as possible, without compromising any international issues, to get French people to Jersey. I put in my report Victor Hugo, sir. It really concerns me that Guernsey seems to be seeing a surge in visitors on the back of their Victor Hugo issues. I've been to see the Victor Hugo Paris apartment. I've been to the one in Guernsey. We don't celebrate Victor Hugo nearly enough, I would say. There's lots we can be doing. Those two wonderful artists in the occupation that are buried in St. Bernard Cemetery, Claude Cahun. We've got masses of Francophile pleasure to have. And people without a passport arrive at St. Malo on holiday, or Granville, and they realise, I won't say the French word, sir, but they say, oh, shame, I haven't got a passport, can't go to Jersey. We want their money, sir. The tourism industry and the hospitality industry is in trouble. I heard this deputy of the Constable of St. Clement's and other people. Hospitality is in this downturn in the UK economy, seeing, despite the Minister and Visit Jersey's excellent work, and Bergerac and all the rest of it, they're seeing some troubled, they're seeing difficult times. Now, some of that is self-induced because of the recruitment problems we've got, but that's for another day, and rising costs of inflation. But effectively, we've got we need to support our hospitality industry, and we need to support the overnight hotels. We've seen enough hotels going out of business. Allowing French visitors with ID cards for 2 days is going to make a difference. And I would have thought that anything that generates economic value, as Deputy Balash said, is of benefit, and it's obvious. I can't prove it, but you can see from the numbers that French visitors would want, if they could, to stay more than just for a day trip. Now, what's going to happen if members dare to cross the ministerial line of the prohibition against doing this? Deputy Balash took the words out of my mouth. Reciprocity, equality. We hear about international standards all the time, sir. I've spoken about them. We've got a CT8 standard. We have our own competence in Jersey. We're not the Scottish Government that can't legislate and do things. We can. We're privileged. We're a peculiar of the Crown. We won't upset the Crown. We won't upset the UK in defence or other things. We're going to behave properly. And the scheme that the wise Home Affairs Minister with her officials last time brought in, and the Minister's carried on, I hope she was going to carry it on. I'm not sure whether or not, maybe she will speak, but I don't know whether or not she was going to carry on the scheme, but Deputy Balash had done the right thing by bringing it to this Assembly to agree, and maybe I've done him a favour in actually helping to get his thing through, even if mine falls, but I hope not, sir. But basically, our members need to think. So we're being told in the report, which I got at the last minute, no, I didn't have any communication, wasn't asked to any meetings, I won't offer because I don't get any answers back, and that's not a falsehood, so it's a truism. I did work on this, I did a lot of work in relation to the immigration order and all the rest of it, and I was absolutely clear that seeing when I did this when I was External Relations Minister, I realised that Ireland, you could go from Brittany to the Republic of Ireland on one of their numerous ferries. And I went to an airport and I asked, can you have French ID, can you have ID cards? Now, if one was really going to be tough with the minister, We'd say all European ID cards, not just French people, and for unlimited stays with no controls. Now that would basically cause maybe a bit of an eyebrow being raised in the United Kingdom, in London, in Whitehall. That might do. All EU citizens, unlimited, because that's what happens in Ireland. You can't go into the Northern Ireland. You've got to stay within the Republic of Ireland. I'm sure it happens, but I'm not aware of any massive security implications between naughty EU ID card holders having a trip up to Belfast or going. I'm not aware of anything. I've tried to look on the internet. I haven't found one case. Not one. Now, is the Minister going to really say and maintain the position that our security is going to be compromised by allowing the form that allows day trippers to be changed from 24 to 72 hours? Is there going to be masses of extra work and lots of things to do and lots of customs officers needing to be employed and security and goodness knows what in order to do this? Well, I don't really think so, unless somebody tells me that I've gone completely into another planet. This is about a sensible, pragmatic, less than the Republic of Ireland, who is in the CTA with us, approach to help actually give some encouragement to our otherwise challenged hospitality sector. In fact, if it's not challenged, I hope they have a great season, but we can give them an even better season. We are nestling off the coast of France, sir, and saying no at the border because people haven't got a proper ID card is ridiculous, when we can say yes, because we're part of the CTA. We've got our rights and privileges, sir. Let's use them. And I look forward to the explanations of why allowing people 72 hours, counting them in and counting them out, is going to create such a catastrophic problem with our diplomatic relations, which I didn't have when I had them. Let's be honest, I didn't. I won't talk about the people I spoke to, sir, but I spoke to people at the highest levels in London and Paris and the regions about this. And I simply don't understand why members are being told what they're being told. Is it the Minister not wanting to do it because she's concerned about it? Is it a threat? Why is it? I'd like to know before I sum up, sir. Thank you, sir.
Thank you very much. Is the amendment seconded?
Yes, sir.
Deputy Tadier, you have a question for the Attorney-General?
I do. Thank you, sir. Probably better that I put it now. So I apologise if the Minister is going to touch on this, but there's been a mention of Ireland and the island of Ireland, I think, so far. Could the Attorney clarify for the Assembly what the position is of Northern Ireland in terms of the acceptance of EU citizens being able to travel to either Ireland or to Northern Ireland in particular with or without only on an EU ID card rather than passport? I understand it might have changed recently, just to see if my understanding is correct.
Is that something that you need some time on or could assist in any event on?
I would need some time, sir.
Some time. Very well, thank you, Deputy the Attorney-General. We'll give that some thought and we'll revert in due course. Does any member wish to speak on the amendment? If no other member, Deputy Lehegra.
Sir, let's sort the thing out in relation to the Republic of Ireland. EU nationals travelling to the Republic of Ireland can use an ID card because the Republic of Ireland is part of the EU. Jersey is not part of the EU, and this creates a fundamental difference and distinction. Direct comparisons cannot therefore be helpfully made. Sorry, sir, my computer's just died. The UK government is committed to the Belfast Good Friday Agreement, and in support of this, ensures there is no hard border between Northern Ireland and the Republic of Ireland. The UK does not operate routine immigration controls on journeys within the CTA, and there are no immigration controls on the Republic of Ireland / Northern Ireland land border There are, however, extensive in-country monitoring and intelligence-led checks. There are not equivalent levels of checks on travellers between Jersey and the UK. And again, direct comparisons cannot be made. EU citizens travelling to the Republic of Ireland cannot then travel onwards to Northern Ireland or anywhere else in the CTA without an ETA and therefore require a passport for onward travel. Hopefully, sir, this has rectified some of those matters. As I set out in my comments paper, I do not support this proposition or this amendment to the proposition. I do not support it because expanding the scheme, which has to date only applied to day trippers, to provide for the 72-hour visits would significantly increase the risks involved to a point that would not be tolerable. The Deputy in his amendment suggests that success of the scheme to date provides sufficient basis to decide on expansion of the scheme. But the success of the scheme to date is largely as a result of its limited nature and the right controls that this allows us to put in place. Risk. Deputy Ozov contends that extending the scheme to 72 hours introduces no new risks. This is simply not the case. Any increase to the duration of time increases the risk. This is particularly the case with regard to the risk of onward travel to the UK or elsewhere in the common travel area, which would be strictly prohibited for those arriving with an identity card. Such travel could be undertaken deliberately in order to evade immigration controls or simply arise as a result of a misunderstanding of the rules, at which point our well-meaning French visitors would find themselves in the UK illegally. Under the current scheme, this risk is significantly minimised. This also increases the risk of damaging our relationship with the UK and other CTA partners. It is imperative that we are and can demonstrate that we are maintaining the robust controls at the border that are required of all members of the common travel area so that we can continue to benefit from that membership. We know that the UK already have concerns about the scheme as it stands, but this can be managed by providing strong assurances about our confidence in the controls in which we've put in place. Were we to extend the scheme as the Deputy is proposing, I, sir, do not believe we would continue to be able to offer those same assurances, thereby increasing the risk to our membership of the CTA. Complexity. Aside from the increased risk, expanding the scheme would also introduce additional complexity. Currently, there is one cohort of passengers per day that we manage, with clarity that an ID card is only acceptable for those on a day trip. This would change under the Deputy's proposals so that there would be a greater number of passengers on Ireland under the scheme at any one time, with varying dates of departure. It would become significantly more challenging for the Immigration Service to maintain the required level of oversight in that context. I also wish to highlight that once expanded beyond the remit of the day trip, it becomes less justifiable to limit these benefits to solely French nationals. Whilst it may not be feasible to travel to Jersey on a day trip from Germany or Italy or Portugal or Romania, it would be possible to travel for a 72-hour trip. If the Deputy's amendment is adopted, citizens of those EU countries might question why they are at a disadvantage to their French neighbours. To date, the French nationals who have not checked in for their return ferry at the end of a day trip have been relocated quickly, owing to them only having been on the island for a few hours. If the time period allowed for stays up to 72 hours, then this would create added complexity to this area and would see a drain on customs and immigration resources in trying to maintain an effective control. The additional risks and complexity that would be introduced by expanding the scheme in this way would certainly require additional resource to manage. For example, if they were required to provide an outward bound immigration control on all flights leaving Jersey. Members will be aware of the constrained position with regard to public finances that we currently face. If the scheme were to be expanded, the Jersey Customs and Immigration Service would not be able to manage within their current budgets, but we cannot guarantee any additional resources. As a minister responsible for that service, I cannot support something which would put the service in that position. Sir, I recognise that the Deputy feels strongly that this is the right course of action to boost the island's economy and deepen our links with our French neighbours. And I don't have any issue with that, and I think it's the right thing to do. And that is why I am supporting 24-hour ID card travellers. Don't forget that the travellers who come on the ID cards are travelling mostly on the day trip ferries and on GFDS, I can't even remember the name, our new ferry operator. So we know and can manage those and where they're coming from. Sir, there must be a balance to be found and the need for security and integrity of our borders, both for the safety and security of the island and to uphold our responsibilities as members of the CTA. Let's make no bones about this, sir. I'm responsible for the safety and welfare of all islanders. And from my perspective, I'm not satisfied that introducing this is manageable. I believe the balance is achieved by maintaining the scheme as it exists, and it remains with day trippers. Also, sir, I do feel that we have to consider not only our tourist industries, but all of our other industries in relation to this. And I fully accept that everybody says, push it and push it and push it until we get face to the wall and hope that nothing will happen. The Deputy's scowling, sir. But I have had emails from people, from members of the public, who do not like the 24-hour ID card for French nationals. What I do not want to risk is that we lose the relationship with the UK and that jeopardises us being able to offer the 24-hour ID card scenario, because we at the moment have, so as I see, a win-win situation. If we do have any pushback, what happens to those who travel every day for businesses from our finance industry? Will we want to see, I'm asking the question, if we end up with a hard border, I'm just putting this out there, do we want to have a hard border with the UK? Do we want people to have passports? We need to consider this when we make this decision, sir. I'm just saying it. But from my perspective, as the Minister currently in charge of this, these are all of the things that I need to consider. I also need to consider the fact that, and I will talk more about this when it comes to the main proposition, we will be having ETA. What does ETA do? ETA is something that we have to have a passport for in order to travel. That piece of information will indicate lots more of information in relation to individuals that an ID card currently has. And I'll leave it at that, sir, for the moment.
Conrad Harbison-Saviour.
Thank you, sir. Several years ago, sir, I was a member of the British-Irish Parliamentary Association. Within the Common Travel Area, I thought it would be fun to see how far I can get with my driving licence. Got all the way to the Republic of Ireland, did all the businesses. Coming back, I was stopped at immigration, and they took away my driving licence and came back 5 minutes later. Said, everything all in order, sir. I'd just never seen one before. And it was handed back and sent on my way. I'm very tempted to support this amendment, sir, as long as it does not damage our relationship with the UK. I've made several inquiries that apparently you can travel from the Republic of Ireland to Northern Ireland on an EU ID card, but travelling across to UK mainland may be a different matter. But there is lots to unpick in this, sir, and I don't pretend to have scratched the surface on this. The principle of people coming from France for 72 hours, I think, is a good one, but I would like the nod from the UK authorities that it will not damage our relationship with the common travel area. Excuse my ignorance here, but I'm curious as to what happens with visiting yachts, if they can come on ID cards or whether they need a full passport if they want to spend a few days here. I'll leave it there, sir, and wait to listen to members. Thank you.
Right, Constable. Mr. Attorney, I'll assume you'll put your light on when you feel able to advise the Assembly. Deputy Miles.
Thank you, sir. I rise really to talk in my previous role as Minister for Justice and Home Affairs and the person who instigated the carte d'identité scheme. And I have to say I totally support the current Minister for Justice and Home Affairs in her rejection of this amendment. It is a very tough path to navigate. I know how sensitive the situation is with the UK. I agree that from an economic perspective, this is a very attractive proposition. But I won't repeat what the Minister has said, but certainly it's my understanding, and I did work for Customs and Immigration for a number of years, it is not as easily manageable. The risk would be higher, much harder to enforce, and it would indeed require more enforcement resources. And to my view, those resources are better spent on anti-smuggling activities rather than chasing overstayers. The risk also for me is about raising our head above the parapet here, so far above the parapet in respect of the UK. When we were first considering this scheme in 2023, I went to the UK and I had an interesting conversation, shall we say, with the then Minister for Immigration, one Robert Jenrick. And I wasn't asking for permission. I was advising the Minister that this was the course of action that we would be taking to change our immigration rules. But in so doing, impressed upon him the very detailed understanding that we had of the risk of doing this, and also to explain in great detail the resources that we had in place in order to maintain the security of the border. And those are conversations that the Minister and her staff will also have had. If the UK were to insist upon passport checks at UK ports and airports, there's a very real risk of disruption to Jersey citizens. Some people don't have a passport. What would we do for hospital visits for elderly people who maybe don't have passports and have to travel to Southampton? But also to point out that not all UK airports are equipped with an immigration control, which might severely restrict the air routes, which we know are already in decline to the United Kingdom. So my view of this amendment, we should absolutely not be taking further risks with our security at the border at this particular time. I think the 24-hour concession is adequate, and I will not be supporting this amendment. Thank you.
Much, Deputy Tadier.
Thank you, sir. First of all, can I thank the Minister also? I think she answered the point about Ireland. So I don't think this is entirely black and white, but ultimately it is a political issue. So I think she was right to make the point that when members talk about Southern Ireland, the Republic of Ireland, that's an EU country. And so I think any comparison with Jersey is problematic. I do have some sympathy with the point, though, that I think is trying to be made, which is to say that where you have a mixed border, if you like. So in Northern Ireland, I still think it's possible for free travel to happen for Irish nationals across the border in the north and south. Let's maybe not get into that, though. It's not necessarily the best starting point, sir. I think the starting point for me about this is, does Jersey have control over its borders or not? So does it physically have control over its borders? Do we know who's coming in? Do we know who's coming out? I think the answer is yes. And I would hope that we have confidence in our Customs and Immigration Service. I've certainly seen the great job that they do when I've been travelling, but also politically when we've looked at that area before on the scrutiny panel that I served on, sir. So I have full confidence that they are up to the job and that actually they could cope with a new system were we to make the political decision today about extending the right for French nationals to stay a bit longer just travelling on ID cards. The Minister's been talking about day trips up until now, but that's not technically true, is it? The law says, or the policy is, that it's 24 hours. So it means that French visitors can stay overnight already if they travel on an ID card. So somebody who arrives into Jersey at 10 a.m. on a boat or presumably on a plane, because we can, private flights, scheduled flights can still come in to the airport. So a French person who wants to can come from Paris or Strasbourg on a plane, or they can take a boat, arrive at 10 a.m. in Jersey, which means they can stay till 10 a.m. the next day. So we've already got that possibility of French people without a passport, with an ID card, staying overnight in the islands at some of our hotels, Airbnbs, with friends, whatever it is, with twinnings. Because twinning is an important issue that we haven't talked about yet. We need to get into that. They can already do that. So overnight travel is already possible. Why not have it for 2 or 3 nights? There's some strange faces going on there. I'm just trying to decipher some of the faces from the camera. So we've established, I think, the fact that French nationals can stay overnight on an ID card. Why not let them stay a couple of nights, 3 nights? I don't accept this argument that we can't have confidence in our own immigration service. I have full confidence in them. I think the real argument here is that we don't want to upset Big Brother. The Big Brother, of course, being the UK. So the question here is, do we have the ability to invoke this change of our free will, or don't we? And I think we've already been told that we do have the power to do that. So it's a question of degree now, isn't it? Because we've already broken ranks with the norm in the UK. The UK, as far as I know, doesn't let any EU countries travel without a passport, even for a day trip. So I think Dover, Calais, whatever the possible routes from Paris through Eurostar, the UK could, if they want to, presumably allow that to happen. They don't do that. So we're already different. We've already pushed the envelope. And I think the point is now, do we have the autonomy or don't we? And I would question, what's the point of all these royal charters that we've had? I mean, we've just had royal visits last year, and every time the monarch comes over, there's a reinforcement of the relationship between Jersey and the Crown. And we're told in recent debates, we've heard about 1204, that magical date, and the renewal of the charters when Jersey, in return for its so-called loyalty, was given these privileges and rights which differ from the UK. But effectively what we're doing here is the Assembly saying, oh no, we mustn't upset Big Brother. We don't really have those rights in reality. So I actually think if we have the rights to allow foreign nationals to travel on ID cards for up to 72 hours, why don't we do it? Just see what happens. I don't accept these threats because we've already had a question today saying that the UK hasn't made any threats. The Home Affairs Minister says she doesn't think that the UK would threaten a Crown dependency. I don't think they would either. I think this is about doing what's good for our economy, good for our islanders. I've just come back from a trip to Granville, actually, which was work-related because it was to do with the twinning arrangements that exist between St. Brelard and Granville, but this was a petanque-related club. So every year we will either go to Granville, they will come here, and we have a bit of fun, but there's an element of competition in that too. And the first thing that the captain of their team said to me when I went to them on Friday, he took me aside and said, "Can you tell us what's going on with passports? Is there going to be any progress on the ID cards?" Half of our club do have passports because some of them need to travel, and that's a higher percentage than most French people, he said, but half of our club don't have passports. They would like to come to Jersey for more than a day, we'd like to spend a couple of nights in Jersey so that we can, so we can socialise with you, we can spend a bit of money, we can visit the island, that we can have a competition, get to know the island better. But we won't be able to do that if we're not allowed to. And I said, well, look, don't worry, there is a debate coming up, and I'll definitely make those points, because I think Jersey's got the ability, certainly got the vires, and I think the capability to do that. I think the 24-hour scheme has been a success. I think we can commend Deputy Miles for that already, and I think I'd prefer to hear a much more positive message coming from all ministers saying, actually, we're not just going to roll over to this perceived threat, which is probably not even real, from the UK. Is that actually we want to have a mature conversation, not as equals, but certainly as two respected partners that can sit down around the table and say, trust us to do this. We'll show you that we can do it. The UK should have no reason up to now to believe that we haven't enforced our borders correctly, that we're any threat to the common travel area. Something the Minister said earlier was that there would be a demand from other EU nationals to say, well, why are we not allowed to travel to Jersey on our ID cards if we extended it to more than 24 hours. But at the moment, that demand could already exist, of course. I mean, there are people not just from France who are in St. Malo at any one given point. There will be people from all over Europe and all over the world who may be visiting Paris and then come to visit the landing beaches in Normandy, then travel over to St. Malo. And St. Malo is a really busy port. On a Sunday afternoon, if you go to the walled town of St. Malo, you'll just see it milling with life, different to St. Helier, I would suggest. And I think we can learn a thing or two from that, and that there'll be, Germans and Danish, whoever in St. Malo that may well want to come to Jersey, but I think they accept at the moment that it's only and they've come over for just a day trip, of course, so that doesn't apply to them. So this idea that we should have the ability as legislators and as an island to also continue that special relationship that we have with France and the regions of France, I think that's really important. We shouldn't just be looking northwards. And I'm really disappointed, and I'd like to hear actually from the Minister for Economic Development in all this, because I know that deep down, certainly from what he said in the past, is that he doesn't usually like to be dictated to by the UK as to what we should be doing. He also acknowledges the fact, I think normally, is he in the Assembly? I'm not there today, but I hope he'll be there for the vote. And I hope that he speaks about where the balance lies in this, because I think we need to be saying to our cousins in France, you're most welcome here. And I would also say to Deputy Morel, as he's often mentioned it in the past, is that we need to be saying strongly to the UK, all this is a result of Brexit. Before Brexit, we could welcome French visitors to our island for as long as we wanted to, with just an ID card. Brexit was your mess. It's a mess that you created. And we're already having to deal with the mess because we're not immune to that. It's had far-reaching implications for us. But this is one area which we don't have to accept the complete collateral damage for that mess for. And we're going to make this small step by saying, because we didn't have a vote in Brexit, we don't have any MPs in the UK Parliament, nor should we, I don't think. But what we can say is that we do have our own autonomy. We do have those rights which have been conveyed to this island over centuries. And if only Jersey politicians who are elected to this assembly had the courage and I think the foresight to make decisions which we're allowed to make and say to the UK, not as a taunt to them, but saying, look, we're doing this for our own self-interests, then I think actually the UK would respect us more and our own people would respect us more. I think the business community who stand to benefit from this would respect us more, and our French cousins who want to come to Jersey and spend their money and spend their time with us, they would respect us more. So there is a counter-argument here. I ask for members to be courageous. I ask for the constables in particular to really consider what this can do for their own twinnings, and actually all those threats, the shroud waving that I believe being made by some ministers, completely unfounded, and I ask members to consider supporting both Deputy Joseph and Deputy Balash in what they're trying to do here.
Minister, did you have a...
I'd like a point of clarification. I think the Deputy may have misled members, sir.
Deputy Tadier, will you give way for a point of clarification?
If I misled members, I'll be keen to hear that, sir.
Firstly, sir, overnight trips are not permitted. And also, it is only on the commercial ferries. Those are the only elements to which people can travel in on a 24-hour ID card.
So can I make that clarification that has been sought then, sir?
Yep. Yes, please.
Yeah. So it's the minister who talked about a 24-hour ID card. So it's either 24 hours or it's not. So presumably, if you arrive here at 11 p.m., so if you arrive here on a scheduled boat, because a boat can be delayed, so it might get in here at 11, you presumably have to stay overnight to get here. The other question I would then put back as clarification, just in finishing off this point, is that we have absolutely no control over delays or cancellations. So a boat arriving, say, at 9 a.m. in the morning, whether it's Monchiel or DFDS, we know from experience that boats do get cancelled, especially when there's only one operator. And if passengers who are here on a day trip can't get back to France, what then happens? And I'd say that's a question that I'd like the Minister to address in her summing up.
The Minister is not going to be summing up this particular point because it's not her proposition, Deputy Ozef
Thank you,
will be
sir.
summing up. Deputy Moore.
And I'd like, thank you.
Sorry, Deputy Moore.
Thank you, and I'm pleased to follow Deputy Tadier's excellent speech. Deputy Tadier spoke of the vibrancy that we find if we travel across the water to Saint-Malo. It is certainly something that I know our Minister for Sustainable Economic Development is keen to see on our streets in St Helier, and particularly in our restaurants and bars. I have to give an example. During the last sitting, I enjoyed a lunch with a colleague, and we visited a restaurant which is a particular favourite of mine, but I found that we were one of only 3 tables in that restaurant, and it was a very sad sight, actually, to see and be reminded of the economic reality that we face, and those particularly running businesses in the island are facing at this difficult time. So, first and foremost, in this argument, I do believe, is an absolute desire to bring some of that vibrancy back to our restaurants and our hotels in the island by offering them a new market and a return to a market that was much loved and appreciated in the island. Jersey has always based itself on its ability to be enterprising, to push boundaries, but to use our unique geographic location and our unique relationship with the Crown and our near neighbours, our cousins, our chers cousins, particularly the Normans. And so this is absolutely what we are here to debate. We need to find a way forward. And I believe that what is being offered is a balanced way forward. It is something that in this modern age, we are absolutely able to offer safety barriers around it. So any person who did try to board a flight or leave the island and enter another part of the common travel area would have to board that flight using advanced passenger information. So the carrier would be aware exactly of who that person was, and they share that information with the appropriate services. Already we have one airline that travels to and from this island and always demands to see photo ID of every single passenger. That is already happening with one airline, and it is something that would most likely happen with other airlines. It doesn't cause any difficulty or delay. It is a simple fact of life of travelling and observing the requirements of safety in the area in which we live. I'm told also that at the private airport, passengers there are not only asked for their photo ID, but also they are required to have a photograph taken of them as they depart our island. And so there is an extra piece of security there. And of course, without very much expense, we can ensure that there are further checks and balances using information technology that is available to us. And of course, people checking into hotels, you hand over their identification when they check in, and it is extremely easy to track and trace people nowadays. If there were found to be any particular additional costs that were required by our services, perhaps they could even apply to the government's own I think economic productivity pot, the £20 million that has been provided to assist with, I believe, this very issue of finding economic growth in a time where there are increased costs, particularly derived by our need to increase wages to those who are working within each of those industries. So, sir, I find, as someone who perhaps was born of a Welsh mother but born English, yet proud to be Jersey, that we can find a balanced way forward to use our unique position, and vive la différence.
Very much. Deputy Jean.
Thank you, sir. And the last two speakers have very eloquently said most of the points that I wanted to raise, but I wanted to maybe emphasise what Deputy Tadier said, which is we've already broken ranks. This has already happened. We've already are different from others. We already are asking for this exemption of having French nationals coming in on an ID card compared to others, and countries or other going into the UK themselves. And the former Minister for Justice and Home Affairs talked about when she visited the last government, the Conservative government's counterpart, to tell their counterpart what Jersey would like to do in breaking the ranks and in doing something different. Talking about the importance of it being good for our economy, for our culture, like Deputy Tadier has talked about, our twinning associations, and especially not just our economy for our restaurants, which Deputy Moore was talking about, but also our hotels. This would then bring much needed support for our hotels, because they will be, then we would have French nationals being able to spend the night or 2 nights. And we are constantly talking about our concerns with hotel beds and with our hotels going out of business and turning into one-bedroom flats. And this would be another way of being able to support hoteliers and the hospitality industry at last. And because of this, because of being able, the former Minister, Justice Home Affairs, talked about how she presented this to the Conservative government. It was disappointing to hear, or not hear, from the current minister how she is talking with this new government, with the Labour government, and how she is now talking with the current counterpart, and what they are talking about in relation to into this proposal. Not only do we need to extend it, maybe as the proposition is, same as it is now, but also potentially making it a little bit longer, so it helps to be, for example, over a weekend or in the midweek when the economy, hospitality economy, may need it more. And as we've seen from the UK themselves and from the government in the UK, they have started to renegotiate some elements of Brexit agreements. So I think, why, if they're allowed to be flexible, why are we not allowed to also take that view when we see it for our economy and our concerns for hospitality industry, but also the concerns that the minister talked about and the risks about it being an increased risk because of potential French nationals using it to go to the UK. But isn't that currently what could happen? You could have a French national who could come to Jersey and then straight go to the UK on the flight. I don't see the difference between it being a 72-hour issue where you suddenly go, oh, I think I'd go to the UK, versus if you just arrive in Jersey and use it as a way to carry on to Jersey. I mean, it's a deliberate decision by that person, I'm assuming, to go to the UK. And so this could happen whether it's within the current scheme or if it's a few days. And my last point, I think, which was something that Deputy Moore raised, is this need to leave Jersey with ID. This happens already at the airport. I don't think it's just one carrier. I think it's most of them now you have to leave. So, of course, those carriers could be asked to say, well, an ID, a French ID should be checked if they are presented with a French ID going to the UK, and said, no, it has to be a passport. I can give you an example that just happened to me, actually, with DFDS. I handed them my British passport a few days ago, going to France with less than 6 months on it, and I was told this was not allowed. So it wasn't an immigration person who told me and looked at my passport and told me this was not able to, to travel on this. It was a DFDS employee. Luckily, I have another passport and ID card as well, if anyone wants to look at that. So, I was able to still travel. But it shows that there are already checks and balances that are not just utilised by immigration officers, but actually the services that off-islanders and others who go in and out of Jersey, they also check these IDs and they ask questions on them. So why can't that just be expanded so that we can also ultimately help our economy, help the hospitality industry, and help to support our culture, carrying on with our links to France. Thank you.
Right, Deputy Moreau.
Thank you, sir. It's always a question of how do you start a speech. So I think I'll start, sir, by saying there's no doubt in my mind, there's not a single question. I wholeheartedly support Deputy Joseph's amendment to Deputy Balash's proposition. But that said, sir, I won't be voting for it. And that's not due to some ministerial whip or anything like this. It's because I prefer to live in the world of reality rather than the world of dreams. And so, sir, I'll explain exactly how I come to this perception. And I'd like to take the Assembly through my thinking, because I think this is how the Assembly should be approaching it. And the Assembly's decision at the end of the day is the one that will carry. But I want to explain really where this all comes from. So this isn't a debate about Jersey's immigration controls. This isn't a debate about Jersey's immigration and customs service and whether it can protect the island and the UK common travel area. It's not a debate about whether any state's member thinks that Jersey's immigration services are fit to do that job. There's no question in my mind. They are absolutely fit to do the job. They are fit to protect our island, and even, in my view, with a 3-day scheme for the carte d'identité, they would be able to protect this island. The question isn't what we think about our authorities in Jersey. The question is, this entire debate is about what will the UK think about Jersey's ability to protect the common travel area. That's the pertinent question, because that's the question which matters. It's the UK's perception that led to, I believe, Deputy Miles taking the approach that she took when she was speaking to the Minister in the past, which was one of quiet diplomacy and one of doing something without making a large amount of noise about it. The result was success on our part. We got this, at the time, temporary provision, where the UK was overlooking it, perhaps. And we've extended that temporary provision now into its 3rd year for this 24-hour system. What we are seeking to do now is ensure that that is a permanent system. The 24-hour day trip is a permanent system. Now, the reality of that 24-hour system is it is actually a day trip, because you have to have a return ticket, I believe, on the same day, and certainly if there's fog or bad weather, then obviously immigration will make the appropriate allowances to enable somebody to stay overnight if their boat isn't going back that day, but they will keep a tight control of them. But in my opinion, sir, what we really are doing here, the choice before us, is similar to the choice you have in the card game of pontoon, 21 perhaps in French, which is, do you stick or do you twist? My opinion, and I say this as a deputy, as an islander, as well as a minister, my opinion is that this is the time to stick and to bank the winnings that we already have. this is not, in my opinion, the time to twist and to gamble those winnings. Because the result of twisting and losing will be that we'll lose everything. That we'll lose the 24 hours and we'll never gain the 3 days. That's the possibility. Oh, and on top of that, as Deputy Lehegara, I think, has said, we could lose access to the common travel area in the process. So I think the consequences of twisting are so significantly high and detrimental to the island that at this current period in time, the right thing to do, in my opinion, is to stick with what we've got. To give it 2 or 3 more years of a successful system that protects Jersey and protects the common travel area. And to make that 1-day carte d'identité situation the norm. Because at the moment, as I said, it's a temporary situation. That becomes the norm. The rhetoric in the UK around immigration perhaps declines a little bit. Then we'll be in a much stronger position in 2 or 3 years' time to push for 3 days, to go ahead with 3 days. But right now, if anyone in this assembly thinks that the rhetoric in the UK or the discussion in the UK, I think actually Deputy Tadia mentioned a mature conversation about immigration. I have yet to see in the last kind of 8 or 9 years since the Brexit referendum a mature conversation in the UK about immigration. There is no mature conversation, in my opinion, in the UK about immigration. It is entirely sensationalist, it is entirely emotional, it is very far from rational. That's one of the reasons why I personally am not willing to gamble what we have and what we can bank on the hope of what would be a much better future. Don't get me wrong, the advantages of the 3-day system would be wonderful, would be huge. People in France would be delighted and there would be more tourism, there would be more benefit to the hospitality sector. But that said, if we gamble, if we twist, if we lose the access to the common travel area as a result, the massive hit to tourism from the loss of UK tourists would be far greater than the benefit of the number of tourists we had gained from France for the 3-day situation. And that, sir, is why, whilst I wholeheartedly support, I want this island to push the boundaries of, because as somebody said, I think Deputy Tadia said, the UK put us in this situation. We did not choose this situation. But if we are to deal with it properly, then it is no point closing our eyes and dreaming of a perfect future. Everyone in this assembly can close their eyes and dream of a perfect future. But the moment you open your eyes, you're forced back into what is and will always be an eternally imperfect world. And so we've got to carefully think our way past this. And I don't believe that jumping now, whilst we still only have a temporary situation around the 1-day ID card situation, jumping now to 3 days, I believe could imperil that 1 day. And it is. I see Deputy Joseph kind of sigh, and I understand. It's not something I want. I want 3 days. I want a week. I want to go back to the way we were before. I want to be able to have free movement in the EU. These are things that I personally want. But no matter how much I dream of those things, they're not going to become a reality today. And so what I'm asking the Assembly to do is to realise that what Deputy Joseph is asking is a gamble. It is at its heart a gamble. And if the Assembly is willing to take that gamble, fine. And maybe it will come off. Gambles can. Sometimes you twist on 20 and you get that ace and you're on 21. Sometimes that happens. But in my view, at this moment, I don't think the odds are particularly with us on this one. I think the odds are quite strongly against us. And I take the signals from that around the lack of rationality in the UK on matters of immigration. The discussion is not rational. The discussion all the way through Brexit completely ignored the economic value of immigration to the UK. The fact that since Brexit, immigration has increased to the UK showed that nobody at the time was talking rationally about immigration in the UK, and that Brexit was never going to be a solution to immigration in the UK. But that's not for this Assembly. What this Assembly has to do is try to judge whether they think, whether we think, the gamble is worth it. So I'll reiterate, the gamble is this. We can go with Deputy Joseph's amendment, and we could succeed, and we could end up with French visitors here for 3 days of the week on their ID cards, and we could remain in the common travel area to the UK. But how likely is that, given the headlines we see about immigration in the UK? The fact that you have purportedly, you have a Labour leader whose constant concern is immigration and trying to make sure that he doesn't lose any more votes to reform UK because he's seen to be weak on immigration. Whilst he knows rationally that immigration is absolutely vital to the UK economy. He knows that, but he's scared to say that because he knows what the tenor of the conversation is in the UK. So we can go with Deputy Joseph. It's a gamble. It could pay off. We could end up all winners. But my personal opinion, not particularly as a minister, but as someone who's looking at the situation, my personal opinion is that the potential loss of that 1 day, and then even further, the potential loss of the access to the common travel area, are probably more likely than us gaining the 3 days. And I'm not willing to lose that 24 hours. I'm not willing to lose the common travel area right now. And it's for that reason that I'm sticking with what I believe is the reality of the situation, rather than the dream of a utopia, which we probably can't achieve right now. But maybe in 2 or 3 years' time, we will be able to, when the UK has calmed down on its concerns about immigration. Thank you, sir.
Very much, Deputy Scott.
Thank you, sir. I haven't too much to add to what the Minister for Sustainable Economic Development was saying, though I think we need to be clear about some of the aspirations that are informing supporters or potential supporters of this amendment. First is tourism. I would absolutely love all the restaurants and hotels in Jersey to be absolutely heaving with tourists. And I don't know why we're just thinking of French tourists. It strikes me that we've got another jurisdiction in Guernsey which doesn't have any of these problems with cars, and we don't aspire to actually bring more people from Guernsey over to fill our hotels. And I guess, maybe just as it's the thing about Jersey that we sort of very much want to emphasise the traditions that we have with France rather than some of the practicalities. If we really want to get people over, maybe we should start marketing towards Guernsey more. But that's one.
Would the minister give way for point of clarification?
Sure.
So how would people get over from Guernsey to Jersey, given that there aren't any boats?
So it's not for me to say comment on the current ferry arrangements, but I do accept that there is a practical difficulty with that at the moment. Also, indeed, that there have been observations on the ferry service to France, but if you don't mind, I won't go there. But the other thing that I think we are talking about is the relationship with the UK. So not just the relationship we have with France, and I know many of us do very much, are very fond of people in France and France generally. The thing that I thought first when I was thinking about this amendment was an oath, and I know I might be associated with those, but we all took one. We all took an oath that to be faithful and bear allegiance to His Majesty King Charles III, and that we will uphold and maintain the laws, privileges, liberties and franchises of Jersey, opposing whomever may wish to infringe the same. So when I'm reading this, I'm thinking, okay, I'm hearing on one hand we've got the right to open our borders to whoever we like, or should. On the other hand, that we may lose something for this island in the form of a common travel area that's really quite important, not just to tourism, but also to our finance industry. So that's what I have to consider under my oath. And I don't believe that there's much of a contest to be perfectly honest. I also think that when it comes to just discussing the some of the actual risks that go along with having secured the 1 day, with the help of a lot of hard work of the minister, the former minister, government officers, that there is something we need to think about in our own community, even doing this, and it's the lack of mutuality with France. We will have people saying, why aren't the French doing this for us? So I think 1 day sounds good to me. I'm going to vote to reject this amendment.
Thank you, sir. This evening at 7 p.m. in Greville Parish Hall, I will be chairing the Jersey Normandy Games Association. 2 years ago, we competed in this competition, the Jumelage Games, as it's called, and I'm not at all smug to say that Greville won it. I will keep that to myself. But, sir, most of the members of these associations, twinning associations, indeed have passports because they know they're going to be travelling to and from the island. However, I will ask the associations this evening, there are 8 parishes taking part on June the 28th, and I will be asking them how this may affect some of their members. I too am concerned about the loss of hospitality. I was just doing a sum in my head. I believe that in my father's and mother's generation, there was about 10 hotels and guest houses in the parish in the Royal Bay of Greville. Now there is 2. Yes, I am concerned about that. But we had a very long and protracted conversation around the table at my scrutiny panel, the panel that scrutinises the Home Affairs Department, and I came to the conclusion, and I too agree with the Minister for Economic Development, that this is too much at the wrong time. I think this is a gamble that we cannot afford to take, and I will not be voting for this amendment. Thank you, sir.
Very much, Councillor. Deputy Balash.
So that was a surprisingly and disappointingly jelly-like speech that the members have heard from Deputy Morel. I'm sorry he's not in the chamber, but I hope he's listening to what I'm saying. I think Deputy Ozov, sir, has made a powerful case for amending my proposition. I drew attention in my report and my opening remarks to the position of Ireland. A Frenchman can lawfully travel to Ireland on his identity card and stay there for weeks, months even, without doing anything wrong. In Ireland, he is in the CTA, just as if he were in Jersey. Deputy Ozov's amendment is seeking something which is, comparatively speaking, very modest. He is asking for a concession lasting not for weeks or months, but for 72 hours, a weekend. That would obviously be very beneficial for our hoteliers, restaurateurs, and shopkeepers. If day trippers can bring in £4.5 million a year, weekenders could presumably bring in at least twice that, 9 million or 10 million. In terms of the length of stay, it is a blink of an eye compared to the position of the hypothetical Frenchman in Ireland. Why can we not benefit our business community, but especially hoteliers, in that way? We talk constantly about supporting our tourism industry. Here is an opportunity to do something about it and act on it. I listened carefully to the Chief Minister. I'm sorry he's not here, but I listened carefully to the Chief Minister at a recent conference organised by the Jersey Hospitality Association, and I'm sure that he can see the strength of the argument. It is a question of balance, and I can understand the nervousness of the Minister and her officials. If 72 hours, why not a week? If a week, why not a fortnight? But we must take each proposal on its merits. The longer a Frenchman stays in Jersey under this concession, the more difficult it is to keep tabs on him. I accept that. But I do not accept that 72 hours is any more difficult to manage than 24 hours, or that it substantially increases or extends the risk. We have, as many members have said, a highly competent immigration service. The arrangement with the ferry company requires the traveller to have a return ticket. Whether that return is on a Friday or on a Sunday seems to me completely immaterial. It can be monitored in just the same way. If the traveller did not present himself on the Sunday, he would be committing an offence and would be liable to arrest. No sensible person wants to get himself into that position. The likelihood of a French person deliberately using this concession to avoid the UK's immigration framework is so remote that I think it can be dismissed. Why would a person use Jersey in that way? He would, after 72 hours, be identified and be a wanted man. If he used Ireland, he could slip quietly into Northern Ireland and then into England without any alarm being raised, because it is not monitored in the same way as it is in Jersey. Of course, there are intelligence-led controls, but that is not the same thing as the practical administrative measures that we take in Jersey. When the Minister writes in her comments paper of more resources being required and the risks of additional checks being put in place for travel to the UK, methinks the lady doth protest too much. The truth is that she really doesn't want any concession at all. She is wearing a police officer's cap and would much prefer to everyone to have to use a passport and get an ETA. And I understand that reaction. For half my working life, I was a law enforcement official. Of course, officials prefer that the law is observed and that no concessions are in place at all. It is, of course, the position of the Home Office. Naturally, they don't want any concessions to be made. But not wanting something is not a justification for taking drastic action to create a hard border between Jersey and the UK. The likelihood of that happening on the basis of the current scheme, even if extended to 72 hours, seems to me close to zero. And I say that as a former Minister for External Relations. It is close to zero because it would be an unreasonable stance by the United Kingdom. And I don't believe that the United Kingdom government would take an unreasonable stance. Furthermore, if they had very serious concerns about it, the island would be put on notice. So a hard border is not going to happen overnight. I don't believe, as I say, that the United Kingdom government would take an unreasonable stance, particularly, I may say, because of the Irish position. Members should not be frightened by scaremongering talk of repercussions. We have a right to extend our scheme, and we should not be frightened of our shadows. If we take a balanced approach, which is what the Minister is inviting us to do, and we look at the other side of the equation and the huge benefits to our tourism industry, the difference between 24 hours and 72 hours is really not worth agonizing about. I would add that this is a request to the Minister to extend the existing scheme, which has worked flawlessly for 2 years or more. It is a request to extend the scheme by 48 hours. I think the Assembly should make that request. If the Minister feels that she needs to wait until the ETA is operational and she can be entirely satisfied then that there are no additional problems, then so far as I'm concerned, that is fine. That is her prerogative. That is a matter for the Minister. And that's the reality which I think Deputy Morel should bear in mind. The reality is that the Minister is being asked to consider an extension to the scheme which many members believe is reasonable and proper. Deputy Ozov's amendment makes sense. I wish I had thought of it myself, and I hope that members will support it.
Deputy Renouf.
Thank you, sir. It's been a very, very interesting debate, and I would come down on this side. I think we all like to be buccaneering and to stand up to the UK and assert our right to take independent actions and show our entrepreneurial spirit and all those other things that have been mentioned. We all do in our hearts. But these are visceral pleasures that must be balanced soberly against the risks. What we have in theory in terms of our powers does not mean it is wise to use them to push to the limits. We have already stretched the system, and a bespoke system has been created for us. But it doesn't seem to me that that means we should go on pushing the system too far. There are clearly risks in extending, and I think it was unwise for the proposer of the amendment in his report to say that there are no new risks. There will be, for example, a lot more people to keep track of. That's obvious, and it is logistically more difficult for that reason alone. So we have the present and former Home Affairs Ministers and the Economic Development Minister all strongly urging us against this amendment, despite the desire they might have to extend these privileges. Because it will cost more, we've been told very clearly that it will cost more money to administer, it will be more administratively complex, and it will create tensions with the UK because whilst, yes, we have the power to do things, they also have the absolute power to respond in their own interests. And as the Economic Development Minister says, immigration is a hot-button topic in the UK. Deputy Balash thinks the UK government would not take an unreasonable approach. But we have been told very clearly that the UK government are not happy with the idea of this extension. So the question of whether we perceive it to be reasonable or unreasonable doesn't apply. I think the amendment before us requires us to take a balanced approach, and I think the Minister and the government has got that balance right.
Very much. Deputy Miller.
Thank you, sir. Sir, I'm not going to say a great deal, and I wasn't intending to speak, but Deputy Balash has used a word which has motivated me to say something, and that word is scaremongering. The Minister for Home Affairs, previous Minister for Home Affairs, Minister for Economic Development, have all put forward very reasoned, rational arguments as to why we should not adopt Deputy Ozov's amendment. And the last time, I'm sure you will all recall, the word scaremongering was used very lavishly was during the Brexit debate. And it was used by those who supported Brexit. It was just scaremongering. All those genuine, valid concerns were scaremongering. Project fear, don't have to worry about it, it's just scaremongering. And how many of those warnings have come to pass? I think we need to be very, very careful about the decision we make today. Thank you.
Does any other member wish to speak on the amendment? Deputy Gorst.
Thank you. So I'm not really quite sure how to intervene in this debate. We've had gamblers, we've had scaremongers or non-scaremongers, and we've had a scheme referred to as a 24-hour scheme. So perhaps I'll start by correcting the record. The current scheme that was very skillfully introduced by the former Minister for Home Affairs is a day tripper scheme. And French nationals who wish to avail themselves of the day tripper scheme under an ID card rather than a passport have to have a ticket to arrive on the ferry, only on the ferry, not on the on aircraft. Not on private yachts. If you're coming on a private yacht, you still have to have a passport. So on a ferry, that ferry company has to have an MOU with the Minister for Home Affairs officials, or maybe directly, I'm not sure. And they have to have a return ticket on that ferry for the same day. It is not a 24-hour scheme. It is a day tripper scheme. That, of course, may or may not change members' perceptions, because is there so much more risk between a day tripper scheme and a 72-hour scheme? And that really is what this debate has been about, which to some extent is unfortunate, because I think, sir, that the previous minister and the current minister show that they are using their rights and privileges and the autonomies that Jersey is rightly proud of well, because they did decide that in managing our borders and remaining within the CTA, they could develop a scheme which allowed, unlike elsewhere, the use of national identity cards. And they were able to put in place or strengthen the protections and the oversights at the borders to make sure that that scheme could not be under threat or challenged, because we were performing our obligations in such a way that meant that we couldn't be challenged around the membership of the CTA. And that was at the heart of what the previous minister did, and it's at the heart of what the current minister, let's just remind ourselves, is going to do in making this scheme permanent, despite the changes that will be made at the border system with all of the new technology that's coming in. So this really is not a day that we should be arguing with each other and criticising each other. It's a day that we should think, do you know what? Jersey can be proud of how it exercises its power under rights and charters, and how it uses its autonomy positively for its economy, but also with the best of governance. And so I don't feel perhaps some of the sentiment that some have mentioned during this debate. And to some extent, some of the arguments in favour of a 72 extension have been premised upon the fact that the Republic of Ireland, which is a member of the European Union, and therefore has itself to seek to manage two, what could say, contradictory systems. One system, the CTA, which requires a passport to enter across the border, and the EU system that says that the standard required of evidence to gain an ID card is sufficient. It has to manage both of those systems. And let's be honest, the Belfast Agreement meant that both Northern Ireland and the UK government and the Republic of Ireland had to put in place and remove a hard border between Northern Ireland and the Republic of Ireland. And of course, that's being further strengthened or weakened or blurred, depending on how you look at it, with the Windsor Framework Agreement. But as the Minister reminded us, EU citizens cannot travel to Northern Ireland on their ID card. They can travel within the EU, of which the Republic of Ireland is a member state, on their ID card. Of course, as Deputy Balash said, there are not, however, the same checks that we have in the port of St Helier and in the port of St Peter for people entering in and leaving their border. Of course there are, for all the reasons that we know. It is a much more intelligence-led approach, as the Minister reminded us. But it is not legal. Those nationals would find themselves illegally in Northern Ireland and they would have to suffer those consequences. And for my part, and I think many members feel the same, they see the success of the current system and the work the current Minister is now doing on that. They know that the pressure on borders is, although the Minister for Sustainable Economic Development said there's no sensible commentary being made around immigration in the UK for the last I don't know how many years, we're seeing that sort of commentary right across Europe and in the US and elsewhere. And we know that that is leading countries, it's leading the EU to put a new electronic system in place at their border. It's leading the UK to put a new system across the CTA. And we will have to manage all of that, and I've got no doubt the Minister will manage that well. But for most members here, in our heart of hearts, would we like to be able to extend that day tripper scheme? I think the answer actually is yes. We heard it really quite powerfully from the Minister for Sustainable Economic Development. Not every member, of course, because some members, their job is to think solely about the security of our border. And that's the job we've asked them to do. That's the job we appoint them to do. Let's just remind ourselves of what the previous Minister did. She didn't come along and say, this is the scheme, that's it. She said, well, we're going to carefully consider how we can implement the scheme on a pilot basis and then review the data, see what had actually happened to those individuals that were using the scheme, and carefully be evidence-led with the data of those that were using the scheme. I don't see, and I of course have to support the Minister for Home Affairs because it is her responsibility to keep the borders safe, but as have I, like the previous Minister, spoken to the UK about how well our system is working and how our system should be continued despite the new border systems being put in place, and how we believe that we protect the CTA and the security of the CTA, and how it could be, we could extend it. Of course I have, as I've spoken to French counterparts about it. But that's diplomacy. That's not quite the same piece of work that security involves. I, of course, stand absolutely ready to support the Minister in any conversations that she might wish to have going forward, or not, as the case may be. But it seems to me that the current Minister and the previous Minister were very strongly of the view that we should, at this point, maintain the current system and support Deputy Balash's amendment proposal unamended. I would rather we did that, but give an indication to ministers that members would like us to explore what was possible going forward, because the maintenance of our membership of the CTA is incredibly important. And we're back to the risk-taking. It's not being afraid of our shadows. It's showing and being able to stand up straight in front of any minister anywhere and any official anywhere and being able to answer their doubts and their concerns and prove with evidence that we've acted competently. And in lots of cases, I believe that what we do in Jersey here is more competent than we see in larger countries. So I think we can stand tall in that regard, but do it with evidence and make our case and explain carefully if, in due course, that is something that we want to work on for all the reasons that members have said, then that is the route that we should take and not just simply accept the amendment today for the reasons that not only the current minister said, but the former minister as well. Thank you, sir.
Very much. Does any other member wish to speak on the amendment? No other member wishes to speak on the amendment? I close the debate and call upon Deputy Joseph to respond.
Thank you, sir. It's very difficult to speak in this assembly as a... sorry, I haven't put my microphone on. It's very difficult, sir, to speak in this assembly as a former External Relations Minister, having done the job of the individual that has just spoken and his predecessor, and to, I don't want to ventilate what actually happens in councils of ministers, but there are tensions, sir. There are tensions. And the job of the external relation, and the Chief Minister's come back in the Assembly, is concurrent. The job of External Relations Minister is concurrent with the Chief Minister. And that means that the Chief Minister can step in at any time. To suggest that a proposal to carefully allow an extension of our right, let there be no doubt at all, I think we've established one thing in this debate this afternoon, Jersey has the right to do this. Yep. So we understand that. We have the right. We can do it. But we have the responsibility to do it properly. When the government that I formed part of came into office in June 2022, all I will say is this. I was faced with an enormous amount of pressure to try and find a solution to increase our French visitors. Enormous. And I had an enormous opposition to doing anything about French ID cards. Now, something happened, members know, I was out of office. All I know is what I can say to members with the oath of office that we take as members of the states, that I made sure that everybody that I spoke to at the highest levels, one never talks about diplomacy, sir, at the highest levels in the UK and France, including diplomats, were aware of the possibility that Jersey would extend a scheme to allow French ID cards. Now, that's all I'm going to say, but I don't want to be... I think members can read between the lines. Now, is it really now the case that somehow history can be rewritten, and today, with a Labour Party that's trying to get more benefits with France, and Jersey being this unique place that does things properly and responsibly, but does have red lines, can't do responsibly a scheme for 72-hour visits to the island with French ID cards. I just simply, I don't understand how it is the case that we suddenly have got to a situation where this Assembly will take on the word of a minister that somehow the UK is going to shut down our put in place a border control if we do this. I've heard all this shroud waving before, and the UK is going to do beneficial ownership registers. I asked the Council of Ministers, current Council of Ministers, whose side are they on? We're not proposing to be, to Deputy Reniff, I'm not being a buccaneer. or whoever said that I was a buccaneer, that just sort of gambling away. That's what they do in other overseas territories. We don't do gambling, online gambling here. We're responsible, and we treat our laws and privileges with the utmost respect. And if any member, and I have not heard anything, not from the minister or the minister who spoke, the economic development minister, has explained to me in words that I can understand, because I can only speak to them in this place, what the risk actually is of extending, and even members were confused. There was some understanding that the scheme actually was overnight. No visitor with a French ID, which, by the way, is a very secure document. It's a very good document. It is the ID scheme that the French national used to identify those people. It's got biometric testing. It's it's not just a piece of paper with your name on it. It's a really clear, and the amount of non-compliance of French ID cards, I did lots of research, like somebody like me does, about non-compliance with French ID cards and whether or not it was a valid document. I'm not saying a French passport, so I'm saying a French ID card that's got biometrics in it and all sorts of checks in it. So, people with a French ID can come to Jersey, and when they book on their ferry, because there aren't any airlines, fortunately, they have to have the return journey on the ticket. Okay, it's going to change from not the same day to 2 days. We all use AI now, so I think that's quite relevant. I'm sure Customs and Immigration, who are very good at all sorts of things, and I commend them in the report that I put, that they haven't had a single, there's been no non-conformers. I compliment them. Razor sharp, our Customs and Immigration. I know they are. They're brilliant. And really, it is a political statement to say, because there's been no evidence put before members to say that it is what it is, that a 72-hour scheme, which undoubtedly, there was a lot of opposition within, I won't go into things, but there was a lot of opposition to the scheme being brought in. But that's why you need an external relations minister that's fairly activist and push those things a bit. But when the situation with Ireland was made clear, it kind of changed the debate a bit, that's all I will say. But really, it's a scheme that we wanted, and I got into trouble by saying I thought it should be done at the time of when we had no French visitors. The scheme has been seen as absolutely flawless and brilliant. Counted in and counted out. You've got to have a return ticket, and you're counted back in. And that's seen a very welcome amount of visitors to Jersey, but only on a day trip. They're not allowed to stay overnight. Now, I say to the constables, who with all their twin parishes, have they asked any of their local mayors what they think about this? I just wonder whether or not they've met any of the residents of France who love to come to twinning weekends and come to the jeu or whatever it is they're doing, or their pétanque or whatever it is, and the fact that do they think they're not law-abiding French people from Avranches or Villedieu-les-Poêles or whatever it is? Of course not. I'm not suggesting, and I'm requesting the minister to do something. If he wants to do it incrementally, 24 hours first and 48 hours next, that's fine. But I'm wanting the minister to do something that's going to be differentiating for Jersey and make a marked difference for economic value to Jersey. The economic development minister, which the chief minister himself discharged for 3 terms or 2 terms, I think if we now live in a world where effectively one minister's told, no, you can't do that because you're going to get a border in, you're going to have passports between Jersey and the UK. I mean, if that's what the Council of Ministers operates at level, if that's the kind of debate that we're dealing with, putting in place a border with the UK would be a constitutional violation of the, it would be a constitutional crisis. We'd have to get you involved, sir. And really, would we do anything that would even come near to risking that? Of course not. We're dealing with French-eyed people who don't have a passport, who want to come to Jersey for a weekend, who are going to be counted in and counted out with all of the checks and balances that are actually there. I mean, I just ask members to really think about, have they heard anything in chucking out Deputy Ozef's proposal that's not buccaneering, that's absolutely sensible, and that used to be in operation for years, by the way, and the political situation with Robert Jenrick or the UK things, all very well, but that's not here. We have to look after Jersey, and our oath of office is to Jersey and the Jersey economy. We will benefit our tourism economy, who are in desperate situations at the moment, by basically allowing overnight stays of French people with French ID cards, which is a valid document. And I'm sure that our brilliant customs and immigration and the economic development minister, if they really need to invest in some IT systems with some AI help, well, these people are going to have a French ID card. They're going to be asked in a hotel to booking. I mean, I can build a system. I was an internal auditor once, so I can build a system if the minister wants to make it pretty clear about how it can work. Okay, you have to have, if you have an overnight stay, you have to say where your hotel is. You have to say X, Y, and Z. Where there's a will, we are a can't do assembly these days, which basically has shroud waving of things that are just not the case. That is, one thing will lead to another. Voting in favour of a request to ask the minister nicely, after a debate, and all the economic development, all of the economy thing, it's not a decision, it's a request to the minister to see whether she can extend the existing scheme for more, up to 72 hours. Now, I don't think that a vote in favour of that is a constitutional buccaneering violation that's going to cause a disruption with UK ministers, all the rest of it. I'm sorry, but I know I've met most of the members of the shadow cabinet, and I wanted to ask the ministers, but they haven't really spoken. Who is it that threatened this, if they have? Because I don't believe them. They haven't said who it is, or whether or not it exists. So we're dealing with falsehoods. And I would have preferred a much more thoughtful, evidence-based approach on what is absolutely false. Jersey is highly regarded in London. We have red lines like beneficial ownership registers and things like that, and we're responsible and proper. And we're not going to put our local people at any sort of risk that is disproportionate to the economic benefit or whatever. You could say that maybe cannabis is more risky to the economic development minister than allowing doing this. It is about risk. If you don't want any risk, you say no to everything. We'd have no border. Well, that's not realistic. We're Jersey. We're not the UK. I've set out, I've been the external relations, the former external relations minister has spoken. I know that former justice ministers believe things that they're told and are told by the UK, and maybe Mr. Jenrick didn't like it. But the fact is, we can make this decision. It's a reasonable request, and our tourism industry is really a problem. We've heard lots of problems about it. We're seeing hotels falling, and I would have thought that Jersey can use its trust and collaboration and respectful position to make something that is modest, can be monitored, and I thought we were a can-do welcoming island, not a absolute risk-averse place that just says no to everything. I don't believe that's the case. I said to Deputy Balash that I would bring my amendment, and I agreed with him that he shouldn't. I asked the Deputy Balash not to accept my amendment, even if he thought it was a good idea, because we needed a separate debate because it might help his proposal to get through. I actually now understand the sense in that, because I think there might have been a sense that there might have been official capture whereby the sensible, completely not risk scheme, because it's monitored so well, would have been put in jeopardy. It shouldn't, it mustn't. And I really urge members, it's a request. We can do it, it can be monitored, and I think we can be better than the shroud waving of basically having a border control with the UK. And so I urge members, particularly the constables, to send a request to the Minister to do something on the basis that it is a very modest extension to something, and I ask members to consider the risks of the Republic of Ireland versus Jersey, with counting them in and out, with all the rest of it, and all the controls that we can put in place to do that, which will benefit our hotel industries in every parish, in every constituency in the island. So I've moved my amendment.
Do you call for the appel? Yes. Appel is called for. I invite members to return to their seats. The vote is on Deputy Ozoff's amendment. And I ask the greffier to open the voting and members to vote. If members have had the opportunity of casting their vote, then I ask the greffier to close the voting. The amendment has been defeated. 14 votes pour, 32 votes contre, 1 abstention.
I propose the adjournment, sir.
The adjournment is proposed. Very well. The Assembly will stand adjourned until 9:30 tomorrow morning. Could I remind members that in 10 minutes we reconvene for a CPA AGM, and I know no one will want to miss that.